Morning, Chairperson.
Good morning, Mr. Ngciza.
Good morning, Chair.
Thank you.
Thank you, Chairperson. Mr. Ngciza, please confirm that you are still in possession of the 2 files we've been using over the course of the past few days.
Yes, I am.
Thank you. When we closed yesterday, we were on page 24 of your witness bundle. 24, please.
I'm there.
Thank you. And we were just about to commence with a new topic, highlighted in bold on page 24. Can I ask you to read that into the record? I'm not sure I'm brave enough to attempt that, please.
Thank you, ma'am. On 20 August 2023.
Can I ask that you start with the heading? Please read the heading.
Oh, yeah, sorry. The heading is Beakley, anonymous emails.
I'm indebted. Can I ask you to detail for the Commission the events you set out at paragraph 74?
Okay, should I read them or just?
Please, in your own words, yes.
Okay. Commissioners, on the morning of the 21st of August, I woke up and I saw on my emails on my phone that was an email that had come through on the evening of the 20th August 2023, which came from a rather funny email address, which was beakley852@yahoo.com, but it also had a name stamp of beakley.ngciza. The email was sent to Jeff Wicks at News 24 with Ms. Kashega, Dr. Mashazi, Deputy Commissioner Spies, Chief Mapieye, Advocate Bihari, and myself copied. The email had a subject line that read favoritism, corruption. And it had as an attachment the charge sheet that I read yesterday for Brigadier Mkhwanazi. It read, "Hi Jeff, I'm reporting on the basis of anonymity. Some time ago you reported a very serious incident to one of our colleagues about one security firm called CAT VIP. The incident took place some time ago, earlier on during the year. My understanding is that a certain law firm was appointed to oversee the matter by charging Julius Mkhwanazi. According to a document in my possession, Julius Mkhwanazi was charged and his hearing was supposed to sit sometime in July this year. However, this did not happen. And as such, Julius Mkhwanazi has since not faced a disciplinary hearing. I suspect that the law firm that was appointed could have received something in return. Please report this to the media and shame the municipality for protecting corrupt officials. Please be careful, however, because Julius is highly connected with Matlala, who's also a suspect in the murder of Decorant Babita, together with the CFO. My case of unfair labor practice has also not been solved by the municipality or by Ekurhuleni. Please follow up on this as we need people like you to clamp down on corruption. I'm told from reliable sources that Imogen Mashazi, who's the city manager, is the one who's protecting Julius Mkhwanazi.
Thank you. The email you've referred to is annexed there as PN12 at paragraph 77 of your witness statement. Could you then carry on and set out for the Commission the events subsequent to you receiving that email?
Yes. Commissioners, I read this in the morning and I called Chief Mapieye because he was also copied on the email. He indicated to me that he has not seen the email. I think he was on his way to drop off somebody at school. It was early morning. He had not seen the email as yet. And I did not respond or not have an opportunity to properly consider the email. because I was a witness on that day. I was a witness in a labor dispute that involved an unfair dismissal case against the municipality. So I went to my arbitration where I was a witness, and indeed we commenced and we proceeded. During a break in the proceedings, where the legal teams were busy with engagements on some documents that the commissioner had directed them to clarify, I noticed that I had a missed call from Ms. Kasheka, and as I was checking my phone, saw that there was a missed call, and then she called again. And I indicated to the commissioner that I need to take this call. It's from my supervisor, and the commissioner allowed me to take the call. When I stepped out to engage with Ms. Kasheka on the call, she instructed that I must come to Germiston. I was in Benoni where the hearing was held. I need to come to Germiston, and I need to come to Germiston with immediate effect. Indicated that I am a witness in an arbitration and I can't just up and go. You know, she said, doesn't matter. You need to be here, and you need to be here now. Okay, where here exactly? You need to be at the city manager's office. I said, okay, fine, let me see what I can do. I engaged the legal rep of the municipality to say that it seems there is an emergency, therefore I need to rush to Germiston. Fortunately, the commissioner is a well-versed person who has been part of the bargaining council panel of commissioners for a while, and he understood my role in the municipality. He then allowed that I should depart the arbitration proceedings. We were almost at the conclusion of the evidence in chief, so I could depart, and if I'm able to, I should indicate whether I'll be able to come back and finalize my evidence in chief on that Monday. This was a Monday. I then left. On my way, I got a call from the attorney that had been appointed to prosecute in the matter of Julius Mkhwanazi. And he indicated to me, hey, there's a problem. He had just received a call from Advocate Kemi Behari instructing him to drop whatever he's doing and to come to Germiston. And he reflected that, but firstly, I'm not an employee of the municipality. I cannot just be instructed to drop everything I do. I've got other clients. And as a matter of fact, he's outside of the Gauteng province, busy with another matter for another client. And I was like, but what did he say is the problem? You know, because I've also been instructed to come to Germiston. He indicated that the problem that Advocate Behari told him is an emergency, is this issue of the Beatley email. And that Advocate Behari has accused them, as the attorneys, of leaking Julius Mkhwanazi's charge sheet. And he was like, but this is absurd. You know, we do our work, we're professionals. We've submitted the charge sheet to the municipality. You know, that is our work, and we've requested the municipality to facilitate the serving of the charge sheet. So you can't come back to us and say there's a leak, and therefore the leak has been done by us as the attorneys. You know, I was like, hey, you know what? I have been called, let me go and hear what is happening. But he confirmed that indeed he was confronted by Advocate Behari regarding the leakage or leak of the charge sheet. I went to the city manager's office, and upon arrival, I did not find Mr. Sheka, and I was told by the personal assistant that I should wait. There's a waiting area. I should wait. She'll contact Mr. Sheka. I was like, but the person phoned me and said that she's here. I'm still busy in another process, so what's happening? I said, DH, I don't know what's happening. I advised that to simply wait. I waited for what seemed like about 45 minutes before indeed Mr. Shega arrived And when she arrived, she was with Advocate Behari. And then I was ushered into the boardroom of the city manager. At the boardroom of the city manager came in as well, had some documents on her hands. We sat, I think I sat next to Advocate Behari. Mr. Shega was opposite, the city manager was at the head of the table. It's a conference table. And it was like, yeah, what is this thing of this beetle? Like, okay, what beetle? What are you talking about, Sam? Yeah, no. You know, you have leaked the charge sheet of Julius to the media. I have leaked the charge sheet of Julius. Where does that come from? No, the charge sheet was given to your office. Yes, all charge sheets are given to my office. You know. Yeah, Kemi, tell him. And Kemi was like, yes, we called the attorney. The attorney said they emailed the charge sheet to you. And I said, yes, of course they emailed their charge sheet to me. All charge sheets get emailed to me. So there's nothing new. They now, but now the charge sheet is found in the Beetle email. But that doesn't mean that it was me, because as much as it was emailed to me, I was not the only recipient of that email. The email had other people as well, people from the department who had worked on the matter. Even my manager, the final charge sheet was also emailed to my manager, was going to facilitate the serving of the charge sheet.
When you say that email, are you referring to the email from the attorneys? No. Which email?
Yeah, the email from the attorneys. So, thank you, Commissioner. Not the Beetle email. The email from the attorneys on the 20th of June. You know, the final draft of the charge sheet. So I indicated that, but this email was sent not only to myself, not only to my manager in my office, but it was also sent to the colleagues in the department that the attorneys were working with in the crafting of the charges. You know, so there's a multiplicity of people that would have had access to the charge sheet. No, but that's wrong. You know, Dr. Mashazi charged that. No, but that's wrong. You know, you can't have that. I'm like, but that is how it's done. The department is the one that must make the case. They are the ones that must be also comfortable.
What was she saying was wrong?
What she said, it was wrong that the charge sheet could have been sent to other people.
Okay, all right.
You know, she argued that no, but that's wrong. You know, how can you have such a thing? I'm like, no, city manager, you must understand. As much as my office must facilitate the serving of the charges, but the people that must make the case in a disciplinary hearing is the department, not my office. The people that are going to witness, the people that are going to talk to the evidence is the department. So the department works closely with the prosecutor in the crafting of the charges, because the prosecutor is going to require them to be witnesses in the matter. So they need to have sight of what exactly are the charges, so that they can be in a position to comfort themselves that indeed we can speak to these issues. Because it won't make sense. You know, you go, you draft a charge sheet, your witnesses can't talk to the charges. You know, is that so? She then confirms it with Advocate Behari, who also confirmed that, yeah, it is correct that indeed we need to engage with the department. So then the allegation now, the accusation, let me not say the allegation, the accusation changes to say, if it is not you, then it's somebody in your office who has leaked this. If it's not somebody in your office, then it's somebody in the department that has leaked this. So I get instructed that I must provide Advocate Behari with the emails that were shared by the attorneys, so that they will conduct an investigation on this leak. So no, it's fine. I mean, emails are emails. I'll send them through to Advocate Behari.
By that, do you mean email addresses to which?
No, the actual email.
The attorneys, the actual, okay. Let me finish what I was saying. By emails, do you mean the email addresses to which the attorney's email was addressed?
What was required of me was to, because they needed to see the email thread, in terms of who would have been emailed. They wanted to see the actual email. So I was to then forward the email thread so that they can be able to ascertain who exactly would have had sight of the charge sheet. So I agreed. I said, no problem, I will do that. I'll just get back to the office and I will attend to that. Then Advocate Behari explained something that was a bit off for me. Now you must understand, DH, we liked calling people by titles, Commissioner. So when we're in a room, there are HODs, CM, and a DH. So you must understand, DH, that, this is a very serious matter. I'm like, okay, what is the serious matter, Advocate? He says, no, what is serious is the fact that Mkwanazi's personal details on the charge sheet. And therefore, this thing of the charge sheet being given to Jeff Weeks, who is an external party to the municipality, is a violation of his rights in terms of the POPI Act. Okay? And therefore, I'm like, okay, I understand that, but there are issues that are also raised.
And what were the personal details on the charge sheet?
The personal details on the charge sheet,
To assist you, Mr. Ngciza,
Yes.
the charge sheet is annexure PN10. It starts on page 292 of your annexure bundle, 292.
when you look at page 292, and this is the funny part, commissioners, it's the disciplinary hearing with the case number between the City of Ekurhuleni Municipality and Julius Mkwanazi, employee number IGE 0120. Those are the only details on the charge sheet. This can be contrasted with the details that will be on on a suspension letter. The details in a suspension letter are more, than this. We have all sorts of things in a suspension letter, including ID numbers and the likes. But in a charge sheet, we don't put what would be termed personal details, because an employee number is an institution detail more than anything else. But this was the allegation that was put to me to say, this thing has got personal information of Mr. Mkwanazi, and therefore the municipality is running the risk of a POPI Act allegation or claim against it.
Based on your HR experience, and you have vast experience indeed, would this employee number be of any possible use or significance to people outside of the municipality? I'm trying to understand why Advocate Behari would have been concerned about such information.
At the very most, but not at the very least, at the very most, what you would do with a pay number is when an employee, for instance, applies for a loan, then they want information about your employer and your employment details, so that when a bank or any other service provider wants to verify your employment, then they can then use both your employee number with the employer, as well as your other details like your ID numbers and the likes. But ordinarily, when they do a verification exercise, it's not just a pay number that is used to verify that indeed this is the employee that we're talking about. Because pay numbers especially in an institution as big as Ekurhuleni, get used all over the place. We use pay numbers in all sorts of documents. So it's easy for a person to pick up another person's pay number.
Oh, thank you. I hope you still remember where you were. Please continue.
Sorry, Miss.
I'm saying I hope you still remember where you were. Please continue.
Mr. Ngciza, you were at paragraph 84 of your witness statement.
Yeah, in the situation in that meeting, quite honestly, was hostile. I was under attack, and I had to push back. I had to push back to say, but even this issue of the personal detail, my understanding is that there is no significant personal detail that is on a charge sheet, that would really compromise the institution. And also, I had to push back on these allegations of leaks. I defended my office. I said, you know what? I know my office has dealt with thousands of charge sheets over the years. And we've dealt with quite high-profile matters where even you had tender irregularities that would be brought, contraventions of the MFMA, serious contraventions of the Municipal Finance Management Act that we have had to deal with as the office. So for me, it didn't make sense that there would be a leak from my office on a matter of this nature. So they then took a view, the city manager now changed the issue to now raise questions about my authority to appoint lawyers and legal representatives. And I answered to say, but this has been the authority of the Director of Labor Relations since the commencement of the municipality in 2000. It's more than 2 decades that we've had this situation in the municipality. No. But Julius is a senior employee. He's a senior person. You can't be disciplining him. You can't discipline Julius. But I've disciplined people that are senior than Julius. I've disciplined people that are on a senior position, a senior rank than Julius, both in the EMPD and in the institution. No. This is wrong. Why do you even have authority to appoint attorneys? But I've got authorities given by your office. And that authority has been there, even for my predecessors. They've always had authority to appoint lawyers in matters concerning labor litigation as well as internal disciplinary proceedings. This has happened with many cases.
Did she suggest who, if not you, should discipline Brigadier Mkhwanazi?
She did not suggest who should discipline Brigadier Mkhwanazi, but what she did was to say this must change. To which Mr. Shega then responded to say, yes, we're in the process of changing it. I had to pose the question, is it changing because of this matter? All sorts of other matters have been handled throughout the history of the municipality, and there was never a need to change something that has been with the employee relations unit.
In terms of the hierarchy, where you have touched on this, but just in this context and to remind myself, where would you place yourself in relation to the city manager? How many places down would you be? Well, I just want to get an idea who then would be better placed according to the city manager to discipline Brigadier Mkhwanazi.
In a hierarchical arrangement, if the city manager was number 1, then the HOD would be number 2 or be number 3. That's how the structure is in the municipality. You'll have the city manager, you've got HODs, then you've got divisional heads.
Meaning somebody like Brigadier Mkhwanazi would then have to be disciplined either by the HODs or the city manager herself? According to what the city manager was saying.
According to what she was saying in that meeting, which does not align to the delegations matrix that is informed by, like I indicated earlier on, that you've got effectively 3 dispensations on discipline management that were applicable in the municipality. You've got the city manager and HODs, disciplined in terms of the disciplinary regulations. The divisional heads are disciplined in terms of Schedule 8 of the Labour Relations Act. And then you've got everybody below the divisional heads who were now part of the bargaining unit. Mkhwanazi was part of the bargaining unit. The authority of the divisional head employee relations in terms of discipline management applies both to Schedule 8 discipline processes as well as the bargaining unit. So as the divisional head employee relations, the only people that I was not authorized to appoint a disciplinary tribunal for is HODs and the city manager. But everybody else in the institution, I was authorized to appoint a disciplinary tribunal for. And I, not only myself, my predecessors, there's precedents all over the place that points to the divisional head having the authority, and it has always been exercised by the divisional head. At no point was there an issue, at no point whatsoever in the history of the municipality until in the meeting of the 21st of August, 2023.
And in fact, I think there was something wrong in the language used by the city manager, because on my understanding, but you'll correct me, it is not as if, for example, in the case of Brigadier Mkhwanazi, you were disciplining him as such. You were packaging the documents that would then be used in the disciplinary process. Am I correct?
Yes. You're correct, Chair. You're correct, Chair.
And on my understanding again, when it came to who would sit or chair a disciplinary hearing, if it was internal, you said it would be someone 2 places senior to the person being disciplined. And then, if not done internally, then a tribunal would be appointed and outside people would then get involved. So you are not disciplining as such someone senior to the person being disciplined. If, for example, Brigadier Mkhwanazi's matter was to be heard internally, it would not be heard by you. You would not chair the process. But someone, did you say 2 places? Someone above, whatever the levels, someone above Brigadier Mkhwanazi would have had to chair. You want to comment?
You are very much correct, Chair. You are very much correct. In this instance, the provisions of Clause 7.6 of the Disciplinary Procedure Collective Agreement would apply because that will be the default position where now I'm appointing an internal. In the instance of Brigadier Mkhwanazi, the only post designations in the municipality that would have been able to chair and effectively discipline would have been senior executive managers who are on C18, would have been divisional heads, who are also above C17 because he was on C17, divisional heads, or else an HOD. All of these would have then been senior to him, and in effect, in terms of the disciplinary code, would have had the authority to then sit and preside over his matter and discipline him. We are quite spot on in that particular respect. Outside of that, then it would be an external legal practitioner who then would not fall within the rank system of the municipality. The hierarchical system of the municipality, it's a legal professional who is competent to then exercise the function of discipline.
And did you get to know the nature of what Mr. Sheka said they were putting together?
Oh, yes.
In order to amend what was in existence so that you should not discipline someone like Brigadier Mkhwanazi?
Yes, but we got to know. We got to know the very next day. We got to know the very next day. I mean,
Yes,
the decision.
very briefly, can you state what this innovation was?
It's in the papers. It's in my statement.
Oh, okay. You're still coming there?
Yes.
Yes.
Okay, let's leave it. Let's leave it.
Thank you, Chairperson.
On this topic that you are discussing with the chairperson, Ms. Ngciza, at paragraph 89, this is where you explain your responses to the city manager in that meeting. And then it is the second part of that paragraph 89 that I think you should explain to us what exactly you were referring to when you say I had done cases that the city manager had instructed action.
Yes.
Can you just explain a bit more there?
I can explain this by way of example, without mentioning names of people. In the Economic Development Department, there was a divisional head who had misconducted themselves. I don't want to use the gender so that, misconducted themselves. And then the head of department, in line with a directive that I mentioned yesterday, that the city manager had issued in 2017, this head of department then did a motivation to institute an investigation. That motivation was taken via my office to the city manager, because the city manager had said, we can't investigate a divisional head without her approving that. Then we submitted that motivation asking for an investigation to be conducted. The city manager approved the conducting of that particular investigation. The investigation was conducted. After the investigation was conducted, another report was submitted to the city manager to say, here is the findings. We are now asking permission to discipline. And the city manager was like, sure, proceed. I then appointed the disciplinary committee. So that's what I mean by it's effectively any instruction that firstly proceed with the investigation and proceed with the disciplinary proceedings. It was not an HOD that signed or appointed. I appointed the attorneys with full knowledge of the city manager. And this is a position that is higher than the Julius Mkhwanazi position.
And the city manager did not have any issues with the fact that you've appointed attorneys. You've exercised the power to appoint attorneys.
Madam Commissioner, like I said yesterday, this came out of the blue, even with regards to the discipline of heads of departments. And during the tenure of Dr. Mashazi as the city manager in Ekurhuleni, we've had about 5 instances where we had to discipline heads of departments. And in all those instances, as much as the appointment letters were signed by her, they would be crafted by me, because it's in my space. I would be the one that then crafts the appointment letter with even inquiries, would be myself, indicating that for this particular matter that has been approved by council, where council has now mandated the city manager to institute disciplinary proceedings, we are appointing this firm as prosecutors. So my role has always been very intricate in all discipline management processes. And that is the only instance where I would then draft the letter for her signature. But all others, I draft the letter, or my office drafts the letter for my signature. I appoint attorneys.
Thank you, Mr. Ngciza.
Thank you, Commissioner. Mr. Ngciza, before we continue with the subsequent events of that day, could I just ask you to turn back to paragraph 85? You're on page 27. And you set out some reflections in paragraph 85. Can I ask you to share those with the Commission?
Oh, thank you. Yes, Commissioners. I want to stress to the Commission that by virtue of my role in the city of Ekurhuleni, where I am responsible for discipline management, and any anybody, commissioners, that has been in a labor-intensive environment would understand and appreciate that discipline management is a very tricky, sensitive function. You know, you get exposed to all sorts of things as a person who is regarded as umqashi. You know, you are regarded and even colloquially called umqashi as the head of labor relations.
You want to translate umqashi?
Employer, the employer. You know, people have that tendency. And remember, indeed, you become the employer because even though you don't chair the disciplinary hearing, you are the one that implements the outcome. A chairperson of a disciplinary hearing will make a finding of guilt and then issue a sanction of dismissal. You, as the divisional head employee relations, are the one that must sign the dismissal letter. It is employee relations that will then issue the termination to the employee that you've been found guilty in this case. Attached is the sanction from the presiding officer. Your services are terminated. You know, so you are always going to find yourself in the firing line. You know, you're going to find yourself in the firing line. I have over the years, like I indicated yesterday, that even before I assumed the function of divisional head in 2017, I had acted and I was always involved, you know, in discipline management from a very early stage of my management career. So I was always in the firing line. I've had a lot of defamatory claims and allegations made against my person, you know, on social media. There's been instances where my name would be the subject of even engagements in trade union meetings. You know, I've been threatened with harm and insults, and I've never received, save for something that I will engage on later on, save for an incident that happened in 2011, which was a very unique dispensation that occurred in the municipality that changed even our labor relations and a dispensation in the municipality in 2011. But I've never received any intervention from the employer. I've never sought, let me be upfront, I've never sought intervention. I've never gone and cried foul to the employer to say, hey, you know what, these unions, these employees are threatening my life. You know, I've never cried foul. These are risks that I understood and accepted as being part of my job. You know, if you are going to be in a labor relations environment, you are going to be bruised here and there. But in all of that, I was shaken by the emerging pattern of interference that emerged with specific regard to this matter. You know, I had said yesterday, I have served under around about 5 city managers. Dr. Mashazi would have been the 5th city manager of the city of Ekurhuleni. None of them has ever interfered with labor relations functions. None. Dr. Mashazi herself, in her first term of office, she served 5 years from 2016 December until around about 2021 November. You know, she had never interfered on very serious matters, inclusive of even matters that involve HODs, would constitute, she would sign the appointments of the attorneys. I would work with the attorneys or advocates in crafting charge sheets against HODs. I would facilitate the serving of those charge sheets, and I would facilitate the disciplinary hearings of those HODs. Senior people to me, but my office would facilitate because that's our role as labor relations, you know. And I've never received any form of interference whatsoever from the office of the city manager. City manager's role was to say, how far are we? Give me a briefing, what's going on? are there challenges? If there are challenges, I would escalate them to her, not even to the HOD HR, directly to her.
So her interference in Brigadier Mkhwanazi's matter, disciplinary matter, was the first and last.
It was the first.
And last.
Well,
No, to your knowledge, or whilst you and her were involved within the municipality?
remember, we are now on the 21st of August. 2 weeks thereafter, I get suspended. So what if indeed there is any other further interference, I'm no longer in the picture to deal with that.
All right, thank you, thank you.
Thank you,
But
Chair.
for the first time, I experienced a situation wherein senior management, and I'm going to articulate this further and more succinctly when I deal with what I would call the cover-up. Senior management, for the first time, was hell-bent on protecting an employee, regardless of procedures of the municipality and processes of the municipality. Senior management acted as if they are shop stewards of this employee.
Thank you. Mr. Ngciza, you were taking the commission through the complaint about your power to appoint external lawyers. You can pick the conversation up again at paragraph 90 on page 28.
Before you do that, Mr. Ngciza, at paragraph 86, you say, this is where you record Mr. Kasheka's reply that we are correcting that CM, and this is about your power to brief external attorneys. Now, before this meeting and before Ms. Kasheka said this in the meeting, had she raised with you ever the issue about your powers to appoint attorneys, one, and then two, that she's doing something about it to change that?
Nope.
This was the first time you heard that she is working on correcting that, whatever she meant with it.
There had never been a discussion, Commissioner. There had never been a discussion. The only discussions about attorneys that I would have with Ms. Kasheka was money issues. We were honestly owing attorneys left, right, and center. Attorneys and advocates, there was just a problem with regards to the budget. Though that is the key discussion that we were having those days. Since she became the HOD, there was always an issue about payment, payment of attorneys.
So
And as a result, in our discussions, because of the payment issue, there was a sense that we need to scale down on appointment of attorneys, because we don't have funds. We are owing money, and therefore, if we continue to appoint, we're simply ballooning the expense. That was the only discussion. It was not about my authority to appoint.
So just to be clear, and at this meeting, this is the first time you became aware that the city manager and Mr. Kasheka have some problems or issues with your power to appoint attorneys. This was the first time you heard anything about it.
It was the first time.
Thank you. Thank you, Ms. Mutase.
Thank you, Commissioner. Paragraph 90, please, Mr. Ngciza.
Yeah, commissioners, as I have said, I tried to push back, and I indicated my issues about my experience in the municipality and the delegations matrix and the likes. But Dr. Mashazi maintained a complaint that I could not appoint attorneys for a senior employee. My understanding of her attack was that Mkhwanazi is some senior employee, so effectively I do not have the right to discipline senior employees. I took a different view. Yes, he's senior, but he's not senior than me. But also, I've been involved in discipline of people that are senior than him. But I realized that, this is going nowhere. I was talking to people that have made up their mind. They've made up their mind, and it didn't matter what procedure and arrangements had been in place. They had made up their mind, and therefore it was not going to assist me to argue the matter any further. Yeah.
Please proceed.
Oh, yeah. There is something I don't think actually it's appearing, Council. During the course of this discussion, there is something I'm not sure where it is in the statement, but during the course of the discussion, the issue of the service of the charges did come up.
Please proceed, Mr. Ngciza.
Thank you. The issue of the service of the charges did come up, where indeed Dr. Mashazi had raised an issue to the effect that, but this thing, even you did not even charge Mkwanas. She raised something to the effect that you don't even charge Mkwanas. I indicated that, but we had received the charge sheet. Klasheka instructed my office not to serve the charge sheet. I actually told her that Klasheka instructed my manager not to serve the charge sheet. And Mashaz was like, okay. It was like, okay. Yeah. And she simply left at that. But yeah, she instructed not to serve the charge sheet, it's fine. Advocate Behari had also indicated that, but I'd looked at the docket. The evidentiary material, that's how we called it. The evidentiary material is not sufficient to sustain a dismissible of misconduct.
As at the time when you left, Ms. Ngciza, did you ever come to know whether an investigation was conducted by Advocate Behari to arrive at his conclusion, and whether any written report about that investigation and the conclusion which Mr. Behari conveys in the meeting, whether there was ever a report about it?
Yes and no, Madam Commissioner. There is no investigation in relation to the substance of the allegations against Brigadier Mkwanas. No investigation was ever conducted to determine whether there is merit to the allegations. Remember, we have the Erasmus report. At that point, the only report that existed was the Erasmus report, and the Erasmus report says there is basis for a case to be instituted. Advocate Behari, I came to learn via Chief Mapieye that indeed on the 21st of June, there was that engagement with Chief Mapieye. He went through and as you can see, the investigation report is 276 pages or so. He went through the report and took a view that there is no basis to proceed. Beyond that, there is nothing. Firstly, the so-called no basis to proceed, there is no communication in writing from Advocate Behari to Chief Mapieye, let alone myself as the person who took the decision, but there is nothing that was actually issued by the legal department that says we've reviewed the contents of the docket or the investigation report. We found that there are certain gaps, and these gaps are such that they would result in this being a fruitless exercise, not even a fruitless expenditure, but a fruitless exercise, because these are not dismissible for 1, 2, 3, 4 reasons. allegations are not supported by evidence. We don't have that. And we do not even have an instance where there was an investigation commissioned on top of the Erasmus report that then looked at the merit of the evidence. We don't have that. The yes, that was the no. The yes is that indeed there is some report called the forensic report. And I think at some point in my statement I will deal with that. But it is not a report that talks to the substance. It's a report that talks to the handling of the disciplinary hearing. It doesn't talk to the substance of the allegations.
Report, I know you're still coming to it, and we've had sight of it. That report doesn't, as I recall, express any view about the merits of or the strength of the charges against Brigadier Mkhwanazi. Am I correct in my recollection of that report?
You are very correct, Madam Commissioner. It doesn't even attempt to.
Yes.
You know, that report was about something else. It had nothing to do with whether Brigadier Mkhwanazi needs to answer for his conduct.
Yes.
You know.
All right. Now, you may have dealt with this yesterday, and forgive me if you have, and I'm making you repeat it. Had Advocate Behari in particular, but also the department in general, the legal department, have they previously, before this, had any role in reviewing disciplinary charges or cases against employees at the level of Brigadier Mkhwanazi, whatever position he was holding at the time?
Madam,
And I'm speaking to your internal processes. I'm not speaking to where you are now at the bargaining council or in the labor court.
Madam Commissioner, the Labor Relations Unit in Ekurhuleni is a fully fledged unit that has a divisional head, 2 senior managers, 1 for compliance and collective bargaining, another senior manager for case management and litigation. It has 6 senior specialists. So the management component alone is 9 people. You know, and that unit functions in terms of all processes that are labor relations related. The legal department, in terms of the structural arrangements of the municipality, would play a role where there is litigation at labor court level. Even then, it's a support role. It's a support role. You know, the labor relations unit in Ekurhuleni since around about 2006 has been capable and indeed has been entrusted with the responsibility of dealing with labor litigation matters from end to end. There's an organizational management principle that talks to end-to-end accountability, which would mean that you are able to account for the start of the function up to the end of the function. The responsibility resides with you. So even my performance contract, you know, detailed that. My delegations detailed that. So would require assistance from the legal department where indeed there is a matter of some intricate nature that requires their attention. But ordinarily, we're fine. Until, of course, Mr. Advocate Behari became the HOD. Then things started changing. Started off with a matter that involved a head of department. I think it was the head of department, and then there was another matter that involved, before even he became the HOD, There was another matter that involved, I can't mention, unfortunately, the designation, because there's only been one person in that designation. So if I mention it, it will be obvious to the world that I'm talking about that case. But there was a matter that involved a very senior person at HOD level, where then the city manager took a view, Dr. Mashazi took a view that I'm close to that person and therefore I should not be involved, and Advocate Behari should play the role that I normally play. Outside of that, he has never been involved. He has never been involved. There has never been a review of a disciplinary process by the legal department. There has never been a need for that. You know, all disciplinary processes were handled within the labor relations unit.
Thank you. Thank you, Ms. McCaskey.
You said, Mr. Ngciza, Advocate Behari said, after his review of the evidentiary material, it did not reveal that there was a dismissible offense. To my mind, that implies that there could well have been an offense, but one that was not dismissible. Did you understand him to mean that, or did he mean there was no offense at all? I hope you get the nuance.
I get the nuance, Chair. I get the nuance. Indeed, the way that it was, he put it, he spoke to a dismissible offense. You know, he says that the evidentiary material does not point to a dismissible offense. My engagements with Chief Mapie, he had indicated to Chief Mapie that the 300,000 rand donation and the lack of procedural compliance with how that donation was sourced could, at best, result in a slap in the wrist. Now, I've checked the disciplinary code. I do not find a sanction called slap in the wrist. You know, so, but nonetheless, to him, these were minor. You know, these were minor. To me, as a person that has dealt with discipline management, I know for a fact that we've dismissed employees for less infractions. You know, there are less infractions that you will find that an employee gets dismissed for. An employee gets dismissed for an infraction, dismiss the cashier there's a concept that we learned at some point called cash rollover, where we dismiss the cashier for cash rollover of 500 rands. You know, you dismiss because that was 500 rands that was supposed to be banked by the municipality, but was not banked, you know, by this cashier. So we dismiss for that, you know. So, but then we get told that all sorts of things that were done are not dismissible. And I was like, yeah.
Thank you.
Thank you, Chair. Mr. Ngciza, you've relayed to the Commission that in the course of that meeting, Dr. Mashazi brought up the issue of the lack of service of the charge sheet on Brigadier. Now, your evidence during the course of yesterday was that the HR manager from your office, who was tasked with delivering that charge sheet, informed you that Brigadier Mkhwanazi refused to accept delivery on the basis that both the city manager and Ms. Xasheka advised him not to do so. So in the course of your engagement with the city manager, did you put that allegation to her? Did you open up a conversation with her about her role in blocking the service of the charge sheet?
No, I didn't raise her role. I raised Ms. Xasheka's role. And she was like, no, it's okay. You know, I didn't say you instructed. I said Ms. Xasheka instructed that the thing must not be served.
And
honestly,
nothing.
I didn't attack her on it.
On it, and nothing further then came from her concerning any potential part she played in blocking that service.
When I raised the issue of Xasheka, you know, sometimes you raise an issue thinking that at least it will ignite a response. You know, Xolani just simply said, yeah, and then she was like, okay, no, it's fine, and moved on, and changed the subject from a discussion on the charge sheet to a discussion on my powers. You know, so honestly, there was no further engagement beyond that.
On the subject of your powers, the next material date is the 22nd of August, 2023. Can I invite you then to paragraph 93 of your witness statement? 93.
Yeah. Thank you, Counsel. This is now informed by the instruction that I had received that I must send to Advocate Behari the emails and the email thread so that he can be able to investigate this issue of the leak. So on the 22nd, I indeed sent the emails to Advocate Behari. Now, later on in the day, I was contacted by one of my employee relations officers who sent me a WhatsApp. And I think I was just driving out of Benoni on my way home. And then I stopped the car and I got into a garage and I opened the WhatsApp. And I saw the document. The document was a document that was signed by Dr. Mashazi and listed Ms. Xolani as the inquiries person. Now, commissioners, the protocol in the municipality is that as much as there is a person who signs the document, the person that is listed as inquiries is the person who drafted the document. So the insistence that the city manager always has is that if you're going to draft a document for her, you must be the inquiries person so that nobody must ask her about the document. You know, this was introduced by Dr. Mashazi to say, no, if you're going to require me to sign, list yourself as the inquiries person so that people must not come to me, they must go to you as the drafter of the document. So, indeed, I opened the message and the attachment and I found the document on PN 13.
Let me assist you. PN 13 on page 311. And Mr. Ngciza, perhaps before we go into the text of PN 13, just in the course of your evidence this morning, take the commissioners through paragraphs 94 and 5, and then we'll turn to the statement, just for completion.
Okay. So I went through the letter that is on PN 13. Having gone through the letter, I contacted Ms. Xolani via WhatsApp, noting that, of course, the inquiries person, as reflected on page 311, is Linda Xolani. So I contacted her. I texted her a message to the effect, "Good evening. I just wanted to check the authenticity of this document." And the document is this one, PN 13. The purpose of my message was to check with her if indeed this document was genuine. At about 20:50, 10 to 9 in the evening that day, Ms. Xolani responded, "What does OCM say?" OCM is the Office of the City Manager.
Thank you, Mr. Ngciza. I'll then invite you to turn to page 311, which is annexed to PN 13 itself. And perhaps before you pass comment on its contents, please confirm that this is the document you received via WhatsApp on the 22nd?
Yes, it is.
That's right. and just read into the record what the subject of the document is in bold.
The subject, the document is dated the 23rd of August. It's addressed to all departments and all employees. It's from Dr. M.I. Mashazi. The subject is disciplinary and...
You said 23rd, am I mistaken?
22nd.
22nd, yeah.
22nd August. The subject is disciplinary and grievance procedure in the city of Ekurhuleni, authorized representatives of the city manager.
Thank you. And the paragraph immediately under the heading in bold, could you just read that first paragraph starting the South African Local Government Council?
The South African Local Government, it's supposed to be Bargaining Council, the B is missing, SLGBC, concluded a disciplinary procedure collective agreement, DPCA, on the 1st of February 2018.
And that is the document we took the commission through yesterday?
Yesterday, yes.
Right. And so please then explain to the commission the context of this guideline or document you received vis-a-vis the DPCA that we went through yesterday.
Like I indicated, commissioners, that how we have structured the delegations matrix in respect of the DPCA in the municipality, you would not have a authorized representative. You would have authorized representatives of the city manager. Hence, even the heading of this document refers to authorized representatives of the city manager in terms of the DPCA. So this document then is a document that talks to the issues that are on, is it 15B?
Thank you.
Yes. So when you look at the issues that are in 15B, this document effectively is a modification of 15B.
Thank you. Mr. Ngciza, then, if you turn to page 312.
Yes.
Under the two bullets, there's a paragraph that reads the above listed functions. So to place it in context, it's discussing the handling of disciplinary proceedings. Correct. So there's a paragraph there that reads the above listed functions required. Do you see that paragraph?
Yes.
Thank you. Could you read that paragraph, please?
The above listed functions required specific authorization from the municipality/city manager to be given to the various layers of management to ensure that disciplinary processes are handled in an expeditious and equitable manner. The collective agreement, however, does not specify who must handle some functions it provides for. For example, in the municipality, who in the municipality appoints the chairperson of an appeal hearing, or who agrees on an appointment of panelists of the SLGBC to hear the appeal if the employee makes such a request, etc.
Please also read the next paragraph.
To usher in expeditious, credible, consistent, and uniform management of discipline within the municipality, the following persons are herewith delegated to perform the above listed functions, as well as all other functions connected therewith as appears from the collective agreement in that regard, as the municipal/city manager's authorized representative.
And so when you read those paragraphs together, the city manager is saying that the aim of this document is to provide for the management of discipline within the municipality by identifying specific persons who must exercise delegated functions. Is that correct?
Yes.
All right. So, Mr. Ngciza, I'll then take you through each of the subparagraphs at the bottom of that page, but I'll invite you to read the heading and to pass a comment in respect of the amendment as it lies there, or the change as it lies there. So, paragraph A1 reads, receiving allegations of misconduct, and under the bullet point, it says HOD of a respective department. Now, please advise the Commission whether that is a change or a retention of the existing procedure.
It's a retention.
Thank you. Immediately beneath that is paragraph A2, which says request for allegations to be investigated must be submitted to HOD Corporate Legal Services. Please confirm that that is the position held by Advocate Kemi Bihari.
Yes.
Thank you. So the allegations then must be submitted to HOD Corporate Legal Services upon determination of a prima facie cause for the HOD Corporate Legal Services to confirm the allegations, consider the evidentiary material, and then submit a report to HOD HR. Please again confirm for the Commission whether that is a modification from the previous document or whether it retains the existing position.
That is a serious modification.
Please elucidate your point for the Commission.
I don't know, Council, whether I should take them through what my response was to this, because my response is very detailed. I don't know how do we want us to.
It's then, I'll take you to your point in your response where you deal with paragraph A2.
Yes.
Does your response, Mr. Ngciza, refer to the numbering, like the A1, A2, B, C, and
Exactly.
so on? Or if it does that, I think he may do that, Ms. Mutlasedi.
Thank you, Chairperson.
Thank you.
Mr. Ngciza, then I will ask you to turn to page 316. That is annexure PN15.
Yes, ma'am.
Thank you. Just to locate this in your witness statement, this is a document where you say in paragraph 97, you describe it as a comprehensive response to the changes in the document What's Up to You. Do you confirm that?
Yes, ma'am.
Thank you. And then you say the purpose of that document is to set out why the revisions are unlawful, inappropriate, and against the best interests of the city.
Yes,
Do you
ma'am.
confirm that? Thank you. When you have regard to page 316, can I ask you again to identify the author of the document?
It's myself,
You directed the document to,
the city manager.
and then please tell the Commission, read for the Commission the heading in bold on the first page.
The heading is Disciplinary and Grievance Procedure in the City of Ekurhuleni, authorized representatives of the city manager.
Okay. I'm going to follow the format adopted with respect to the guideline issued by the city manager, which is that I will read the proposed, the new guideline, and I will then ask you to respond to it. So we have already addressed paragraph A1. I have already read for you paragraph A2 into the record. Can I then ask you to comment for the Commission on what you described as the serious revisions to paragraph A2?
Thank you, Council. Commissioners, on page 317, I detailed, I think it's from 317 to 318. I submitted to the city manager a detailed analysis of the implications of A2. I don't know, can I just read them?
Chairperson,
Yes, Mr.
my proposal, I'm in your hands, but my proposal is that in light of how lengthy it is, it might be a time-consuming exercise.
I also wanted to suggest that perhaps if you could just deal with the salient or set out the salient points that you made.
Thank you, Commissioner, Chairperson. The first issue that I raised with A2 is the requirement for the request for allegations of misconduct to be investigated to be submitted to the CLS. In the municipality, I had indicated this in my testimony before, Commissioners. The municipality has got various investigations units. You know, we have the monitoring and evaluation investigations unit, which investigates infractions that would happen on the e-notice system. where you have people that have registered cars or even licenses in an inappropriate manner. So those people investigate, and they've got a legal obligation to do that investigation in terms of the Road Traffic Management Act and whatever acts that they use. You have that. You've got the Integrity and Standards Unit of Internal Affairs, the Erasmus unit. You've got loss control of, again, EMPD, that also deals with this. You've got the Internal Audit Department that also conducts investigations. And then you've got MPAC, the Municipal Public Accounts Committee, that also would institute investigations. Now, MPAC is even more serious because this is chaired by a councillor, and councillors are part of the committee. And that committee has got a legal obligation and powers to actually institute investigations. Now, A2 says you can't have an investigation unless it's approved by the HODCLS. You know, it's just impossible. You know, effectively, you are saying that councillors cannot investigate. They must get the authorization of their junior, because all of us are juniors to councillors. That's the political leadership of the municipality. But also all these other units that have got vested investigation authority. Now that authority is taken away. They must, before they can conduct any investigation, they must get approval from the HODCLS. It's just impossible.
And sorry to intervene, Mr. Ngciza. Then on the facts as they've been relayed to the Commission today, how would that change affect the sequence of events we are informed of? So, for example, we understand that the allegations of misconduct against Brigadier Mkhwanazi were brought to the attention of Commissioner Spies. Commissioner Spies then directed Colonel Erasmus to prepare the investigative report. That investigative report made it to your office. What effect does A2 have on that sequence, if any?
It means the Jeff Weeks media query, because within it is an allegation of misconduct. When Spies received that, he would not be able to appoint or instruct Erasmus to conduct an investigation. He would have had to take that query and give it to Behari. And Behari would then consider, in terms of A2, if you read A2, a request for allegations must be submitted to HOD, CLS upon determination of a prima facie cause for HOD CLS. And that's convoluted. That's seriously convoluted. And I deal with that. But effectively, it is Behari who must now consider the evidentiary material of what at that point. It's still just a request to investigate, but you must take it to him to consider whether there is material that actually must now form the basis upon which an investigation must be conducted. You know, the collective agreement commissioner says an allegation of misconduct. You know, it does not even say that it's an allegation of misconduct in writing. It says an allegation of misconduct. In our circular in 2018, we insisted that the allegation must be in writing, even though the collective agreement does not go that far. The parties in the bargaining council recognize that you might have employees who might not be in a position to actually articulate an allegation in writing. Now, you have this situation that changes and says an HOD cannot investigate in his department, cannot conduct an investigation in his department. The HOD must go to another HOD, and that HOD must actually make a determination on whether indeed you are going to investigate.
I see practical difficulties with this. At what level should the allegations be for you to take them to the head of legal? It may be the barest of allegations, and then references made to a prima facie cause. Who gets to the level of a prima facie cause? Will the HOD legal or will the head of legal then have to do an investigation herself to get to the level of a prima facie case? Or must she or he determine the existence of a prima facie case on the basis of the bare allegations without any investigation having been conducted? Unless I'm misreading it, it's confusing to me. It raises practical difficulties. In fact, most matters would not pass the level of a prima facie cause for an investigation to then be conducted. They would never pass because it would, in most cases, just be the barest of allegations.
And hence I address that, Chair, on page 318. What you have just indicated now is the same sense that I had. I'm saying I put it on Roman figure 2, upon determination of a prima facie cause. The memorandum is rather confusing in its articulation in this regard. There is no clarity on the following aspects which are pertinent to a determination of a prima facie cause. What is meant by upon determination? Who determines the prima facie? The request to investigate submitted to HODCLS, no clarity on who will conduct the investigation or whether the HODCLS is intended to approve that a line HOD conducts an investigation in his or her department, or that the HODSLS will conduct the investigation himself. Is the determination as made by whoever, because it's not clear, contingent on the investigation report, which is not clarified on who, on how same is to be conducted. And I want to agree with you, and that's exactly what my thoughts were when I responded to this, to say it will create serious problems for the municipality. It's really impractical.
I'm very sorry. If the idea was for the head of legal to do the initial investigation that brings her or him to the level of a prima facie cause, that is all that she or he would ever be able to do within the municipality, because you say you handle thousands and thousands of matters. So would they still, within legal, be able to do the work that they exist for? It's I don't know, you know better. You are part of HR. Maybe you know that you sitting there would be able to say, no. They have capacity. They could have been able to do all of that.
Impossible. I would not be able to do it. And I'm not the head of department. The legal department has to deal with everything in the municipality. There's issues of supply chain management. There's issues that concern bylaws, municipal courts. There's a whole lot of things that they have to deal with. And this HOD must oversee all of the issues. Now, for him to actually conduct investigations, and as you say, Chair, some allegations are just bare allegations. They are bare allegations, and some issues. Yesterday, we talked about whistleblower issues. In most cases, a whistleblower will just give you that, something is happening there, but they're not going to provide you with the evidentiary material. Now you have an investigator must go and conduct an investigation and get the evidentiary material. And it cannot be at the level of an HOD. The norm has always been you have the HOD of the department receives allegations of misconduct, causes the allegations to be investigated in his department by people who've got know-how of how the department actually functions and operates. Then those people are able to draw the information, craft the report, annex the detail or the evidence to their report. Then we can take it for determination, But this was just a bit, yeah. But I raised that, the issue that you've noted, Chair, besides the fact that the municipality has got standing investigations units. There are people appointed there who are paid by the municipality, and now you are simply saying they can't do their work unless the HOD CLS approves that they do the work.
So as matters existed prior to this, there was devolution of powers across the municipality.
There was what, Chair?
The work was spread out.
Yes.
The work was spread out
Yes.
across the municipality.
Yes.
There would be an investigation there, all the way across by various people who would then produce the dockets or dossiers, and then eventually they would land at your desk.
Exactly, Chair. That's how it operated. And quite honestly, it was a seamless process.
Yes.
You have issues in your department, you investigate them. Once you've determined that indeed there is prima facie cause, we are the head of department, you know, you are the head of department. You have a right to make a determination that, you know what, indeed this employee seems to have infringed or contravened rules.
That
Then you
comes
take
from
it.
that comes from a collection from all these focal points, and then everything comes from you. The legwork having been done.
Yes.
Now, as is, the suggestion is for the head of legal to do the legwork. Because how else does he reach a determination of prima facie cause where there are bare allegations without that legwork having been done?
Effectively.
Impractical, it seems to me, unless the people who crafted this were to come and explain how they thought it would work.
And why I had to craft this response as a person who has got the technical know-how in terms of how discipline management is dealt with in the municipality. I'm raising these issues with the accounting officer to say, but your letter has got these practical problems, you know, besides the fact that it creates a mess of the process, you know, as opposed to what the intention was. You know, if the intention was genuine, and quite honestly, I want to maintain that this is because of one case. We've never had a problem. There's never been an issue until the Mkhwanazi case. There's never, ever in the municipality. We handled discipline. You know, I go on and you will see in my memo, I even talk about a comparative analysis that I conducted that speaks to how we as Ekurhuleni, where if we were to benchmark us against the other metros in Gauteng, where we were in terms of discipline management as a municipality.
Mr. Ngciza, that letter at 311, or that directive, circular at 311, which tells you what the new regime is going to be, it says at page 312, the paragraph above A1, there's a paragraph there, and then it sets out what is intended to be achieved with this new regime. And it says to usher in expeditious, credible, consistent, and uniform management of discipline within the municipality. Had there been an issue on those aspects in the municipality, how discipline was applied, expeditiousness, had those issues been raised and discussed with the HOD and you at any point?
Madam Commissioner, there's always issues that are raised with discipline management in every institution. And this stems, the biggest issue that was ever raised that we've had to deal with as labor relations is age analysis. That has always been the biggest issue that we've ever raised. You have a dismally hearing. You constitute it, you appoint the committee, the first sitting, you go to the first sitting, you get a request for further particulars. You know, you have to deal with the request for further particulars. Once you've submitted the further particulars, there are points in limine that are raised. Once you've dealt with the points in limine, there's a recusal application that is raised, and boom, 2 years down the line, the case is not complete. That is the biggest problem that we've ever faced. You know, age analysis. So when now mention is made of expeditious, one would think maybe the intention is to ensure that you shorten, you know, the lifespan of dismally hearings. but it cannot be expeditious in relation to the constitution of a dismally hearing. Before the 2018 collective agreement, we had a 2010 collective agreement that said, if you do not institute discipline, after I've made the determination, my 12th April determination, if I do not then actually ensure that the dismally hearing commences after 3 months, I had to go and apply for condonation in terms of that collective agreement. And that was always an issue, not only on municipality, but in the sector as a whole. Because there is this problem, even after you've made a determination, you find that we delay, municipalities delay in instituting the actual case, in commencing the dismally hearing. So that, for me, expeditious must relate to that, that once you've got your investigation concluded, start the case as soon as possible. So there's never been an issue. We always start our cases within the 3 months period. Credible, I don't know about credible, because all our dismally hearings have been credible. The only way that you can determine the credibility of a dismally hearing, in my view, is that if indeed you conduct a dismally hearing and you dismiss an employee as a result of that dismally hearing, you then take the matter to arbitration and in terms of dispute resolution mechanisms. And then a commissioner says, you know what, the conduct of the employer was abhorrent here. You just had it in for this employee. Then it questions the credibility of your process. But that questioning of the credibility of the process will then arise out of an arbitration award that will be issued. That will talk to, you had it in for this employee, the evidence was shoddy, your processes were just malicious and all sorts of things. Then you can talk credibility, But I can assure this commission that for as long as I've been the divisional head employee relations in that municipality, we've never had questions about the credibility of our processes. I think when I read this, I went into, okay, credibility when you charge Mkwanas is not a credible process. Because I've never had questions even from, and remember we submit reports on a quarterly basis to the oversight committee that deals with corporate services in the municipality. And we've never received any feedback from political leadership that says our processes are not credible. They will complain about how long it takes. That was the main issue.
I know Commissioner Balo is still asking. I just want to ask a quick question on the question of credibility. A finding of not guilty would not necessarily be an imputation on lack of credibility. Is that not so? On its own.
Yes. To answer that, Chair, I once had a nice debate with the member of the Mayoral Committee for Corporate Services around that, and I gave my own understanding of what discipline management is about. When, as an employer, you find an employee not guilty, you should be happy, because it then says that you've got a honest, credible employee in your service. Indeed, there were allegations against the employee that you brought as the employer, and you find that, no. An objective analysis of the situation says the employee is not guilty. To me, that says you've done your work, because discipline management, in my view, it should not be a punitive measure. It should be more of a corrective measure. And if indeed you find that, no, these allegations do not actually result in a dismissal, they do not result in a sanction, and then you should, as a manager, I'm happy, I'm fine, I'm fine, because I've done my part, and indeed, an objective person has said there is nothing to it, so it doesn't call into question the credibility of the process.
Can I just explain the base of my question, or the premise of my question is, in that paragraph, a reason is provided to justify these changes, right? So that we've got expeditious, credible, consistent, and uniform management of discipline. That's why now these changes. And my question was to seek to establish with you whether there had been a problem about these issues that now are purportedly being remedied with this new procedure. And your answer so far is there had never been these issues.
To give it straight, when I took over as divisional head in 2017, we had about, in our case roll, we had about 250 disciplinary cases. At the time of my dismissal, I had 51. We've managed discipline, not only in terms of managing the case roll, but also managing conduct and behavior in the institution. So honestly, these are good principles. Make no mistake, indeed, this is what is required, no problem. But it is not because there was a lack of. There was no lack of. In fact, we had improved.
Thank you. Thank you, Ms. Ngciza.
Let us adjourn and resume at 11:22. Let's adjourn. Apologies for being 1 minute late. Let us resume, please.
Thank you, Chairperson. Mr. Ngciza, we are on page 318 of your annexure bundle, page 318. We are still discussing your comprehensive response to the guidelines issued by Dr. Mashazi. If I could turn your attention to the heading next to Roman numeral 3. The heading that reads, for HOD CLS to confirm the allegations. So this pertains to the allegations of misconduct. In that paragraph, you describe the HOD CLS as a super HOD in the municipality. Could you explain to the Commission your justification for that statement?
Yes. The system of delegations in the municipality, commissioners, as approved by council, and I think at that point, the system of delegations was approved in 2017 by council, and it was still applicable. It places an obligation on each HOD to manage discipline in their departments. Now, if an HOD has to give to another HOD the responsibility to confirm whether indeed allegations exist in their department, effectively that means that HOD is subservient to this other HOD, And I viewed this as effectively creating a super HOD dispensation in the municipality. Instead of all HODs being on the same level, now you have this HOD that becomes almost like a supervisor of the others in terms of discipline management. That's why I then said that this means that the HOD CLS, Advocate Behari, becomes a super HOD in the municipality, and it cannot be correct.
And for completion, to your mind, upon considering this new guideline, this new regime, what is the impact, particularly of A2, on the existing investigating bodies within the municipality? So what becomes of integrity and standards, for example?
Well, one of the key considerations for an investigation body is independence. If indeed a person is appointed by the municipality, and we train these people, the municipality has spent money to train people to be investigators. Some of them indeed have got qualifications as investigators. whether in the police environment or in the general environment of the municipality. These are trained professionals, and we appointed them. You know, they earn substantive packages. Some of them get to be even managers in their fields within the municipality. And then all of a sudden, in order for them to conduct investigations, they have to be authorized. You know, the 2017 dispensation that was created with that case that I referred to yesterday effectively meant that you can't investigate a divisional head without the approval of the city manager. You know, that was, and I had no problem with that, because indeed there is a council resolution that was adopted on the 1st of December 2011, which said that the appointment of divisional heads is delegated to the municipal manager. So the municipal manager becomes the employer, you know, of the divisional heads. And therefore, it's fine if the municipal manager is the one that must make a determination on discipline processes for divisional heads. Not a problem. But everybody else has got their HODs, you know. Everybody else has got their HODs. So even these investigative units are within departments. And when they conduct their investigations, for instance, commissioners, loss control, the loss control investigators investigate matters of misappropriation of council assets, where a council asset has been misappropriated or stolen or anything that has happened to a council asset. Loss control, because there is even a committee, it's called the Loss Control Committee of the municipality, that looks at all departments in terms of their management of assets. So if indeed issues arise, either from a loss control committee meeting, where indeed there is submissions that a particular department is reporting that we've lost this and this, then it must be investigated how those losses occurred. Is there anybody that can be found or can be suspected of having done some wrongdoing in respect of the handling of those assets? Loss control conducts that investigation stemming from the committee itself. But also, where you've got a case of theft in a department, you have a right as a department where you do not have the expertise to conduct the investigation, to request the chief of police to appoint loss control to conduct that investigation. You know, now those people are appointed there for the purpose of investigations. What this does, it means loss control cannot do their work, even if it's stemming from the loss control committee. What this does, it effectively means that you have changed the terms of reference of that committee. What this does, it even changes the terms of reference of MPEC. You know, there is wider implications where indeed even a committee of councillors would be subject to the determination that is made, and that committee has got legislative powers.
What's MPEC? Forgive me if you've told us before.
It's Municipal Public Accounts Committee. It's like SCOPA in Parliament, but for the municipality, you've got MPEC. So, and there's a number of investigations. Internal audit is a key investigation. It's an investigations department. What then happens? Internal audit cannot conduct an investigation. It must go to HODCLS before they can conduct an investigation. Those are the implications, you know. And we've got commissioners, we've got wily unionists, shop stewards that will pick up on these things and be able to say, but where is the approval from the HODCLS? You know, on an internal audit report that says this employee has misappropriated council funds. You know, how did you conduct the investigation as internal audit? Do you have the approval of the HODCLS as per the 22nd August 2023 memo?
Mr. Ngciza, the new guideline deals in paragraph B with the appointment of presiding officers and employer representatives to run a disciplinary hearing for more serious offenses. You have comprehensive criticism about that at the bottom of page 318. You deal with paragraph B. Do you see that?
Yes, ma'am.
Thank you. Could I ask you to take the Commission briefly through your challenges with that aspect?
Thank you, Commissioners. The first issue that I raise is that the DPCA is a time-bound peremptory collective agreement. What constitutes serious offenses in municipality is wide-ranging and cuts across all occupational categories. So, what paragraph B says is that firstly now, and I do not want, Chair, I do not want to actually sound as if I'm a crybaby. You know, they've taken my power now. No. I'm raising pertinent practical issues. Paragraph B says the HOD, after consulting the accounting officer. We are a municipality, at that time, the municipality had about 20 departments. You know, they've shrunk them. I think Chief of Police also testified on the measures and institutional review that took place. I think now it's about 14 or 15. But still, it's a sizable number of departments with more than 20,000 employees. In order for the HOD-HR to appoint a presiding officer for an assault case at Waste Department in a depot in Niger, she must consult the Chief Accounting Officer. It's an assault, 2 workers fought against each other. You know, and therefore, she cannot appoint the disciplinary tribunal without having consulted the accounting officer to deal with a matter that involves general workers in a depot. I mean, it's taking it too far. That's the first issue. And I mean, if indeed the accounting officer and the HOD don't get to actually sit and have that consultation and have a record of the consultation, by the way, because if now there's an appointment and there's no record of the consultation, it can be said that the HOD-HR acted ultra vires, paragraph B. And that would be a point that if I was a shop steward, wily shop steward, I would raise. The DPCA gives authority of appointing disciplinary committee to the accounting officer or her authorized representative. Therefore, the authorized representative has authority. You know, if the city manager appoints an authorized representative, that person then has to exercise the authority. Paragraph B says, no, the person does not exercise the authority. The exercise of the authority is contingent on a consultative process and therefore is contingent on the accounting officer giving a sort of consent or some form of agreement that, okay, fine, charge this person or appoint. Now, why do you need to do that?
There's a technical legal issue around the process of consultation.
Yes.
If a provision says after consulting or after consultation with, that means the one who decides or the one in whom the power resorts consults the other, but the ultimate decision rests on the first mentioned person. But if the provision says in consultation with, then the decision is the decision of both people, and there will be no decision if the two have not agreed. It seems to me that this one is the first the first example I've given, because it says after consultation. It does not say in consultation. So therefore, the accounting officer does not have to agree, even if she or he, I will say she or he because it will not always be a Dr. Mashansi. Even if she or he does not agree, the first mentioned person can take the decision.
Yes.
Although, of course, you know, with the power relations and all that, it may never happen in practice if the one being consulted does not agree. But that will not be a function of the law. It will be a function of power dynamics.
I understand, Chair, and I agree with the analysis that you're providing. The issue for me is that, therefore, the HOD cannot appoint without having had the consultation.
But none of what I'm saying detracts from the point you are making,
Yes.
which is basically bottlenecking everything, you know, like your general workers at some depot somewhere, all of that, having to go all the way to the city manager, even if she's merely being consulted. That will result in serious bottlenecks.
Yes, sir. And hence the time-bound processes. So the second one that I had raised is the issue of the authority. My reading of the collective agreement, and not only my reading, but the practice, or how we have always interpreted the collective agreement, not only in Ekurhuleni, but even you'd find that even in terms of unfair dismissal disputes that had arisen, it has always been accepted that the authorized representative of the municipal manager then assumes the full delegation to perform the function. You know, we've never had to perform a function that are delegated in consultation or after consultation with the delegator. You know, when the person is delegated, you are given the authority. Therefore, you exercise the authority, you know.
And Mr. Ngciza, sorry to intervene, if I could draw your attention then, still on page 319,
Yes.
to Roman numeral 4, where you raise issues around capacity. Could you make some remarks in respect of that, please?
Yes, thank you, Council. What I was raising here is it's in line with what I've testified on, commissioners, on the role that labor relations or employee relations plays, which is not just simply appointing the presiding officer, but you know, you have to manage the process, you know, and having appointed the committee, you are also responsible and accountable for how the dismarriage case or the hearing has progressed. You know, you take, like I indicated, the principle of end-to-end accountability. You know, you are fully vested in the process. Now, we have a situation here, the HOD will appoint and then step back. You know, it's not clear in terms of where the process then resides in terms of the actual management of the dismarriage hearing. And one of the things that, as the appointer, you know, and I've had to do this as the person who appoints the dismarriage committee, you can be subpoenaed to go and explain what happened with the dismarriage process, the appointment process itself, but also the management of the dismarriage hearing. You know, for instance, you took a decision that you are going to appoint legal representatives. What informed that? There is a challenge around that. How? What was the rationale and everything? So one was also concerned about these issues, that you'll have an HOD that at that level does the appointment and leaves the process and is not invested in the process.
And maybe if I can ask you a question just about general impact. I earlier asked you, Mr. Ngciza, what the implications of this new regime are to the investigative capacities within the city. But what are the practical implications of this new regime on your office? Apologies if I sound facetious, but some of the provisions go to the heart of functions you've described as belonging to your unit. And tell me if you agree, but seemingly render some of those functions redundant. Care to comment on that?
It's, your question is not facetious at all. Don't even think it is.
Please.
May I answer?
Please answer.
Okay. I deal with that, even though I do not deal with it extensively, but I deal with it under B of my submission to the city manager, where I state contractual obligations. And Roman figure 2 on page 320, I raise the issue on contractual obligations in relation to the functionaries in the Employee Relations Division. The functionality of the division is thus put into question, as the accounting officer taken a decision to close the Employee Relations Division by stripping it of its core functional obligations. Discipline management, I would say, constitutes about 60% of employee relations functions in the city. Because discipline management does not just simply end with the issuance of the sanction. It goes on, to arbitration, and would have our people that must go and deal with those arbitrations. Goes on to labor court reviews, labor appeal court appeals, and therefore we get involved from start, end-to-end accountability again, from start to finish. So we're raising these issues. All of a sudden, when you look at, for instance, the 2018 memo and other memos that are in the pack that speaks to the delegations matrix and the role of employee relations in the discipline management processes, this effectively, this new dispensation meant there is no role for labor relations. There is no role. I think when you look at the entire thing, labor relations comes up under I on page 313. I on 313. And that's the only place handling of step 3 of the grievance procedure shall be dealt with, shall be submitted to the office of the HOD HR for coordination through my office and ensuring a register is kept. That the people that can chair those step 3 grievance hearings is the head of department HR, the divisional head employee relations, others as may be specified by the city manager. That's all. In the entire discipline management processes, the divisional head now only has to sit in for step 3 grievances. When the contract and the performance agreement requires the divisional head to be the person that actually manages the entire discipline management processes of the municipality. But the delegation that he has is one of just sitting in and hearing a grievance. That is the impact that this had. It did not just simply change a delegation's matrix, but it also had a contractual implication. Not only on the divisional head only, but also the employees in the unit.
Indeed. And in light of your role at the time, apart from receiving this memorandum via WhatsApp, please inform the Commission whether you were consulted, with respect to the contents of the memorandum, the possible consequences not only on the employment contracts of people in the unit, but also any other potential financial implications.
No. Remember, I was only told on the 21st of August that we are correcting it. And what correcting it meant was never articulated. I then got to understand the correction when I saw the memo. But no one spoke to me.
Mr. Ngciza, before we conclude on this document, at the bottom of page 320, still in your annexure bundle, 320.
Yes.
Yes, you have a page 320. You have a heading there titled A, the Julius Mkhwanazi case. And you discuss it from page 320 to page 321. I don't require you to read the contents of that discussion into the record, but please provide a summary for the Commission about why you deemed it necessary to include specific mention of this case in your memorandum and the reasons therefore. Thank you.
Commissioners, before I dealt with the Julius Mkhwanazi debacle, I raised some pertinent issues with the city manager. As you can see on page 320, I started off by saying, to take away what constitutes close to 50% of the operational obligations of a unit is to render that unit redundant. The following questions are thus pertinent. One, what informed these changes? What thought process has been put in place on the implications of the operational implications of the changes so put? Given the fact that the changes are with immediate effect, what about the processes that were put in place but said cases had not commenced? Should the dockets or files of these matters be redirected to the HODCLS and HODHR as per the immediacy of the processes that are now put in place by the memorandum? Should the answer to 3 supra be in the negative, what defense should the employer representatives and presiding officers advance to the unions when they are challenged on their appointment and thus jurisdiction of the disciplinary hearing? Because already there were matters that were pending that had not even commenced. And now were we supposed to issue new appointments or what? Should the answer to 3 supra be in the positive, then what about the impact on the timeframes envisaged in the DPCA, noting that the provisions of the DPCA are peremptory? You have matters that indeed you have appointed, and if indeed those people are to proceed, I had a concern, on the timing. In conclusion, I cannot ignore some pertinent issues that must be ventured into in assessing the manner in which this whole matter has been dealt with. I therefore must raise my misgivings in this regard as follows. A, the Julius Mkhwanazi case. The urgent meeting held on Monday at the boardroom of the city manager required some serious reflection on my side on the direction and manner in which the municipality is taking on the handling of discipline. The following critical issues arise. Roman figure 1, how and why did the HODCLS, that is Corporate Legal Services Advocate Behar, get involved with a concluded investigation report by the police? Is this not, and the police in this instance, I refer to EMPD, not SAPS or IPID. Is this not tantamount to interference with discipline management, especially given the fact that this was highly irregular and not found in any prescript of the municipality? Roman figure 2, where in the DPCA is the role of assessing evidentiary material? Where is such a role in the contract of employment of the HODCLS or even on the system of delegations? In essence, where did the HODCLS get the jurisdiction to embark on such a process? And I raised this because I'm sure even Chief Mapia indicated that Advocate Behari had instructed, or rather Dr. Mashaz had instructed the Chief of Police to take the docket to Advocate Behari, and then he made an assessment of the evidentiary material and took a decision that there is no case. So I'm asking the jurisdiction, where does that come from? Where does he have the authority to do that? Why did the HODCLS, in the exercise of the questionable function of assessing evidentiary material, not engage the following persons? I'm raising this if indeed you are going to make a determination, at least consult those that have been involved with the matter. A, the investigation team, in order to understand the processes that were embarked upon in the collation and assessment of the evidence gathered in the matter. B, the appointed prosecutor, to understand the approach sought to be adopted in formulating a winnable case. C, potential witnesses, to understand the strength and resolve of the persons the prosecutor seeks to rely on in presenting the case of the municipality. None of these people were engaged by Advocate Behari in his making the determination that there is no case. Given that the test in the disciplinary proceedings is one of a preponderance of probabilities, a concept prevalent in human resource practices than legal nuances, what tools of assessment were used by the HODCLS, since clearly no engagement were held with the persons referred or mentioned in Roman figure 3 supra? Given the fact that the appointed prosecutor is a labor law expert who happens to be an advocate, how does the HODCLS, who does not possess notable experience in labor law, override the considered opinion of the labor law expert? Since when does the HODHR stop the serving of a charge sheet to an employee? Why was this done with this specific case? And where in the DPCA or any other prescript of the municipality, inclusive of the system of delegations, does the HODHR have the authority to stop a disciplinary process from proceeding? 7, if there is no legal prescript giving the two officials the authority to interfere and in fact stop disciplinary misconduct proceedings against an employee, even after a prosecutor had determined the existence of a probable cause for the institution of a disciplinary hearing, what steps is the accounting officer going to take to handle the blatant misconduct of the said senior managers? I go on to indicate that the framing of the memorandum issued on the 22nd of August 2023 leads one to hypothesize, based on the conspectus of the evidence and the flow of events, especially the discussion held on Monday, the 21st of August 2023, that the anonymous email questioning the handling of the Mkonazi matter and potential corrupt activities associated therewith, that the memorandum is a post-ex facto legitimization of the misconduct that occurred with the handling of the Mkonazi charge sheet. The memorandum is a regurgitation of the processes that were embarked upon by the two HODs in the handling of the Mkonazi matter. I'm raising
the misconduct you are referring to there, sorry to interrupt you. You're referring to the misconduct of the two HODs, not Mkonazi's misconduct.
Yes.
So you're saying by interfering with the handling of the, I would say prosecution, not investigation.
Yes.
They were committing misconduct.
Misconduct.
And they are trying to legitimize it through this new delegation of authority.
Exactly.
Thanks.
That's why I say, Commissioner, that it's ex post facto legitimization, because what they did was not covered by a prescript. Now, in order for them to justify what they did, they then introduce a new prescript. But at the end of the day, as of the date that they were doing what they were doing, there was no prescript that regulated that. But the new prescript that then gets introduced on the 22nd of August 2023 is exactly what they did in June of that year. This raises serious questions on the integrity of the processes we engage upon as the city administration. That the fact that a single matter as the impact of influencing 2 decades-long processes that have stood the test of time and challenges mounted by various parties is unfathomable. Of greater concern, however, is the fact that the 2 departments that are at the heart of good governance are found to be right smack in the middle of a wanton disregard of council resolutions, the system of delegations, and policy framework of the municipality. They've shown a total lack of appreciation of a vital function that speaks to the stability of the municipality, i.e. discipline management and its concomitant nuances. Discipline management, and my understanding, commissioners, is critical to a stable institution. If indeed we are going to allow employees to disregard rules, disregard policies, disregard processes, like Brigadier Mkhwanazi had done, and we protect that, you know. Can you imagine if indeed other employees get to learn about what Brigadier Mkhwanazi has done and he got off scot-free? What is to stop others from doing what he did exactly, getting into some form of memorandums without following due process, issuing letters to service providers without following due process, you know, effectively giving institutions or entities all sorts of authority that resides in the municipality? You know, what type of state are we breeding?
To paraphrase what you are saying, this would introduce or create a culture of impunity.
Exactly, sir. There is also a labor law principle that is at play, which has the potential of wreaking havoc with the manner in which discipline management is exercised in the municipality. That is consistency in the application of discipline. You know, and I know that the labor courts have actually emphasized this. You know, you can't seek to discipline Xolani on this, but then you leave out offense on the same misconduct. You know, there must be consistency in the application of discipline. What is to stop organized labor from demanding the withdrawal of disciplinary matters against their members, given the fact that the existence of allegations of serious misconduct is no longer a sufficient cause to institute disciplinary proceedings?
Thank you, Mr. Ngciza. In paragraph B on page 321, you have a heading there titled "The Handling of Disciplinary Cases in the Municipality," but you've made some remarks regarding that at an earlier point in your...
It's off. Sorry.
Is it 12 midday again?
Honestly, I switched it off. I switched off the phone, but there's nothing I can do.
Divine intervention.
Yes,
Right. No problem. At the bottom of the page...
Have you switched off the alarm now? I hope it's not on snooze because it will come on again.
I switched off the phone. Let me switch off the phone again. Oh, yeah. And a friend of mine laughed at me last night. I don't know how to operate a phone.
Mr. Ngciza, more importantly, have you prayed so that it doesn't ring again?
I have prayed. I've prayed. Thank you.
Thank you. Mr. Ngciza, at the bottom of page 321, you have a heading there titled "C, the frittering away of the Employee Relations Division." You've given some overview, some concluding remarks already on this topic, but let me give you an opportunity to say anything further you would like to say before we conclude on this document, under the topic of frittering away of the Employee Relations Division.
Thank you, Council. Yeah, the first issue that I raised is the taking away of the labor law litigation function to the HOD CLS. Commissioners, on page 323, you have a delegation. This is a delegation that has been a standing delegation since before me, with my predecessors. But if you read the delegations, there is clarity. A, the Divisional Head Employee Relations has got a delegation to institute and defend labor law, labor relations related legal action in all courts, arbitration and or labor dispute resolution bodies, including quasi-judicial courts on behalf of council. So I could institute, and I've instituted proceedings against trade unions and the likes. For instance, when there's an unprotected strike action, then I would institute interdict proceedings. Now all of a sudden this was taken away. Instruct lawyers, including junior and senior advocate, to act for and on behalf of council, sign all documents necessary for its registration, institution, and defending of labor law, labor relations applications, etc. Hereinafter called legal proceedings for the said purpose, including deposition to affidavits, etc. So this whole thing now meant this is taken away.
Aren't A and B typical functions of an employee relations division and manager, typically? Is that not what you find in organizations?
That's my experience. That's my experience, that indeed a labor relations director would have such authority, and the labor relations director in Ekurhuleni has always had this authority. So that is one, and all of this now all of a sudden was given to the HOD CLS.
There's that last paragraph on that same page. Do you want to say something about it? F.
On page 323.
Yes. What is delegated to you in paragraph F?
Yes. I had the authority to sign invoices that are submitted by attorneys, firms of attorneys, which would be inclusive of council invoices, if that those invoices combined, did not exceed 500,000. So if we're running a matter in the labor court, and I then receive invoices, I would have the attorney's invoice, the junior and the senior counsel, and then I would authorize on all invoices and also authorize the payment voucher that would then be submitted to the finance department. So I had that authority up to 500,000. You would see that on page 324, it indicated that if indeed the amount was to go beyond 500,000, then I would seek the approval of the HOD HR for the payment of an amount that is above 300,000.
Yes, you make, now when you spoke, you make specific reference to labor court matters. What about the internal disciplinary hearings where you've utilized external lawyers? Does that fall under F as well?
Yes.
Okay, thank you.
All matters. Remember, there's this delegation, and then there's also another, it's called a specimen, document that is issued. That specimen document is for when finance receives my invoices or invoices from my unit with the payment voucher. The signature that is there must correlate with the specimen document. And the specimen document would also indicate the values that I can sign for, or the maximums of the values that I can sign for. So this was all part of the process of ensuring that there is proper financial management systems in place.
Thank you, Commissioner. Mr. Ngciza,
We're in the filtering away.
Yes. Page 321. Unless you have any further remarks.
I've got 322. Commissioners, I think 322 is exactly what we're discussing, where I say that there was a taking away of the authority to appoint firms of attorneys thus impacting on the authority to institute and or defend labor law matters, inclusive of the CCMA, SHBC, and the likes, and also the taking away of the authority to appoint officials in disciplinary hearings. And then, even though it's not in the memorandum of the 22nd of August 2023, there was some task team that Advocate Behari, wanted to be formed that would report to him on the handling and management of dispute resolution functions, which were my functions. And quite honestly, I was getting paid handsomely for them. And then all of a sudden now those functions are not to be performed by me, and I would still receive the salary. Very funny.
I'm looking at page 320, the paragraph that starts to take away what constitutes close to 50% of the operational obligations of a unit is to render that unit redundant. You have said to us that what you were left with was presiding at certain type of grievances. Do you think your quantification of 50% is accurate? Was what was taken away not significantly higher than 50%?
No, it's accurate in the sense that as much as discipline management, Chair, constitutes a sizable amount of work that the Labour Relations Unit does, and even in terms of the structural arrangement, because I developed the structure that we're now using as the municipality, the bulk of my employee relations officers were in the unit that deals with case management and litigation, and discipline management was part of that unit. But there is also other work that we do, which speaks to institutional stability, institutional stability, which ranges from, I established communication structures from a depot level. I had what was called a depot communication structure, and I had a unit that was dealing with depot communication structures and departmental information structures, where we manage relations in the depot so that indeed you avoid a situation wherein there's an escalation of problems or conflict in the depot that will result in industrial action. So it's one of the things that I invested in, and as a result, the institution bought into that arrangement so that we try, because a strike issue, and I think I mentioned something to that effect, a strike in the municipality, for instance, in 322, where I mentioned 2 strikes, institutional strikes that were very costly and very heavy on the municipality. In 2008, we had a strike that cost the municipality damages of up to 56 million rands, the quantification of the damages that we incurred. In 2011, we had another strike that lasted for about 3 months that cost the municipality 74 million rands. So we invest a lot.
Yes.
We don't just deal with management of discipline, but the investment on relationship management.
All right. Let me say this. Subject to anybody taking issue with your quantification, I will accept your answer that your quantification of almost 50% is fine.
Thank you.
Let's leave it there. Thank you very much.
Thank you, Commissioner.
Thank you, Chair. Mr. Ngciza, if I could ask you to turn to the final paragraph of your response. It's on page 322. The final paragraph. The paragraph starts with the words, the representative trade unions. Do you see that?
Yes, ma'am.
Indeed. If you go to the, let me read that sentence first, actually. It says, the representative trade unions have also raised queries with me as the DH employee relations on the wisdom that informs the memorandum issued on the 22nd of August 2023. In the second sentence there, Mr. Ngciza, you highlight the far-reaching implications that will be visited upon the municipality on the implementation of the memorandum. And there's a request of sorts to the accounting officer to rethink the contents of the memorandum and seek counsel. My question then is, did you ever receive a response to this memorandum or any form of communication that suggests there was a reconsideration and a seeking out of counsel?
No. This memorandum, commissioners, was submitted to the Office of the City Manager on the 29th of August. Nothing, not even an acknowledgement of receipt.
Nothing subsequent to that?
Nothing.
Did you copy the functionaries mentioned at the bottom of page 322?
Let me be honest, Commissioner, I don't remember. I don't remember what I actually, in that email I sent to them. Let me not speculate. I don't have the email, but I know that the email itself was sent to the city manager.
Thank you, Mr. Ngciza. That would then conclude the discussion as it relates to your comprehensive response, which is PN 15. Could I then ask you to turn to page 30 of your witness statement? If we can go back to your witness statement.
Yes, ma'am.
We are now on paragraph 98.
Yes.
And please inform the Commission the events of that day as set out there.
On the 2nd of September, which I think was a Saturday, another anonymous email was sent to Jeff Weeks by the person who was using the pseudonym Beakley. And in that email, the person went on to describe how Dr. Mashazi is shielding Brigadier Mkhwanazi from his disciplinary proceedings. And Beakley even raised an issue to the effect that my powers were taken by Dr. Mashazi as part of this process of shielding Mkhwanazi.
Perhaps for the further elucidation of that point, could you turn to page 336 of your annexure bundle?
Yes, I'm there.
That is annexure PN 16, and that would be the second email received.
Yes, ma'am.
Yes. Mr. Ngciza, could I ask you to have regard there to paragraph 4 of that email? You've provided an overview of sorts of its contents, but could you have regard to paragraph 4 of the email? It begins to support my stories.
Paragraph 4. To support my stories, Imogen Mashazi decided to issue a directive to the effect that from now on, only Linda Kashega and Kemi Behari are going to authorize any disciplinary hearings. I've pasted the document to this email so that you can see for your eyes. This was done in order for Imogen Mashazi to protect her peoples inside Ekurhuleni and is using Linda Kashega and Kemi Behari.
And just to further emphasize the point you made in your witness statement, if you turn to page 337, which is the next page.
Yes.
Do you see the second paragraph on that page?
Yes.
It starts with your name.
Yes, ma'am.
Yes, could you please read what Bixi says there in that paragraph.
Xolani Ngciza powers have been taken by Imogen Mashwazi deliberately.
Thank you. Could I then ask you to turn to paragraph 99 of your witness statement?
I'm there.
Yes, and
Ma'am?
yes, I'm giving you the page number. Yes,
On
then.
page 99. On the 7th of September 2023, I was served with a pre-suspension letter and suspended soon thereafter.
Thank you. And if you go to page 338 of your annexure bundle,
Yes.
that would be the pre-suspension letter. Do you see that?
Yes.
Yes. Dated 7th of September, directed to you.
Yes.
Is that correct? Now, Mr. Ngciza, could perhaps then in light of your evidence under this heading of the Bixi anonymous emails, as well as the ultimate issue of a pre-suspension letter to you on the 7th of September, could you explain to the Commission whether you believe these events were all related and culminated in the events of the 7th?
Thank you, Council. Commissioners, to me, honestly, the Bixi emails just wreaked havoc with my life, in the sense that soon after the email of the 2nd, which was on a Saturday, we proceeded and we were busy preparing for a workshop on the institutional review and implementation of the municipal staff regulations that were promulgated by the minister, which came into effect around about the 1st of November 2022. These were regulations that were now going to have an impact on how we manage HR processes in municipalities across the country. Quite honestly, the letter of the 7th, came out of the blue. You know, we sat on the 6th preparing for the workshop that was to happen on the 7th, and I was playing a pivotal role in those preparations, to the effect that Shega even remarked to say, hey, you know, had it not been for these protocols that the council has, actually you should be the one that leads the HR team tomorrow in the workshop with councillors, because we're going to meet all councillors and we're going to workshop the councillors on the staff regulations and how they're going to impact the institutional review process in terms of especially the political office, you know, the political offices. Now you have that full day engagement of the management team. You play a role in terms of structuring even the presentation, teasing out the key issues that we need to concentrate on when we actually deal with these matters that must be workshopped. And then boom, the next day, you get served with a suspension letter. And even though the suspension letter speaks to issues about qualifications, those issues, in my view, had been dealt with. But nonetheless, you get issued this. Now, fine, you get issued with the suspension letter, primarily because, in my view, I had raised critical issues in my letter that was served on the city manager's office on the 29th of August. And I believe that the issues that I've raised in the letter that we've just discussed now, effectively went to the extent of exposing the malice that the municipal manager and the two HODs had in their attempts to protect Mkhwanazi and therefore to deal with anybody and everybody that was involved with the investigations and the possible discipline of Mkhwanazi.
Just one brief point. Yesterday I asked you a question whether, based on what you knew, you thought what Ms. Tlasheka was doing and saying was motivated by her fear of the city manager. I understood your answer to be in the affirmative.
Yes.
Now, can you please explain to me why you say her conduct was malicious? You've just referred to her conduct and that of the head of legal as having been malicious. So in the context of my question posed yesterday and your response to it, can you please explain why you say Ms. Tlasheka was acting maliciously?
I'm saying that she acted maliciously in consort, of course, with the city manager and Advocate Behan, in the sense that as much as I honestly believe, commissioners, that the drive to protect Mkhwanazi was a Mashazi-driven drive. That was the Mashazi project. It's Mashazi that had these close links to Mkhwanazi. I know Ms. Tlasheka. I know, I've worked with her since she arrived in the municipality around about 2015. She came in as a divisional head that was dealing with what was called functional line services. And I've worked closely with her on a number of projects and processes in the municipality. I know her capacity as a person. The environment that I can say erupted when her predecessor left and how her predecessor left, that's where this problem started in my view, where her predecessor was the HOD-HR, was even excluded from a process that resulted in the reappointment of Mashazi. And she was then put in charge of that process from an HR point of view. And then her predecessor was not even shortlisted for her position. I'm in the position with all the qualifications and experience and everything. The position gets advertised. I don't get even shortlisted from a position that I've held, and my junior, qualifies for shortlisting. It's such a mess. And then she got into this close proximity with Mashazi, and she honestly found herself captured because everything Mashazi wanted, she did. Everything, And unfortunately, some of us are the characters that we are. You would be like, but no, this is wrong. What I mentioned yesterday about Anfunu Ngcoliswa, I don't want to be shouted at. You could go to HR in Ekurhuleni and ask employees. They would tell you. We had an HOD-HR who genuinely fears the city manager. An HOD-HR on every issue effectively has abrogated the responsibility and given it to Advocate Kemi Pehara. I answer advocate. No, Maslindo advocate. No, advocate uthini. You know, that is the type of environment that was created. Whether it was as a result of maybe, or rather as a combination of, on the one side, fear, and on the other side, lack of capacity to stand for your own and to actually lead the function that council has appointed you to. For me, it was a combination of both. So I view it as malice how the things then turned out, because there was malice in the sense that I would rather sacrifice this person, these processes, in order to protect myself from ridicule and being lambasted. You know, I'm at that level, to me, that is malicious.
But Mr. Ngciza, there is, of course, the third possibility that she made common cause with Dr. Mashasi.
Yes, there is that possibility as well, ma'am.
Yes.
Yes.
Thank you.
Thank you, Commissioner. Mr. Ngciza, you've indicated today that your belief is that the facts that you spoke up and you took steps, you know, opposing actions to shield Brigadier Mkhwanazi resulted in your suspension on the 7th. Is that right?
Yes.
And if regard is had to the notice, your notice of suspension on page 338, it sets out in paragraph 2 distinct reasons warranting the suspension, your suspension, reasons relating to your academic requirements.
Yes.
Yes. And, you know, please comment to the Commission whether, in your view, those reasons are valid or you disagree with them, and that you maintain that the real reason is the position that you took in opposition to the shielding of Brigadier Mkhwanazi.
Commissioners, these are invalid reasons. This is just a guise that was used to camouflage the real issue. Firstly, I've worked for that municipality since 1997. When I came into that municipality, I provided my qualifications. I moved from being an intern student to an admin officer. And every time you get promoted, you respond to an advert. That's how the municipality works. There is an advert, you respond to the advert. When you respond to the advert, you provide your qualifications, you provide your CV and everything, so that the people who are going to shortlist have a sense of who are we shortlisting. You provide the documentation. Get appointed in 2003 as the manager, provide the documentation. You know, in 2011, I was almost appointed as the Director of Labor Relations. I provided the information. I even went to the extent of a psychometric assessment in 2011. You know, it took about 3 months for the municipality to make a determination between myself and the eventual person who was appointed. But nonetheless, the information that speaks to my qualifications, my skills, my competences as an individual, who in fact literally grew up in the municipality, you know, were provided. Then 2017, provided. The municipality at all material times had my qualifications, at all material times. And then I get suspended because I'm told that I didn't provide my qualifications. I'm in my second term as a divisional head employee relations. And I get told, no, you didn't provide your qualifications. I mean, seriously, in which world?
Do you have any idea as to what triggered the need for you to produce these qualifications?
Mr. Commissioner, or Chair, in the email that we dealt with of the 2nd of September, there is an individual that is included that I believe was weaponized by the municipality. It includes that individual who happens to be
336.
336. Yes, I would not mention the name because I was told not to mention names, but under the CC, the last individual that is CC'd, you know, the usual names that have been mentioned all along, actually the last before SPIS, you know, you see the CC there is Imogen Mashazi, Linda Klashega, Xolani Ngciza, Kemi Behari, and then this individual, and then Rivo SPIS. This individual happens to be a General Secretary of a union that is unrecognized in the municipality. But the way that this person has got unfettered access to all sorts of things, inclusive of personnel files of employees, you know, is able to write all sorts of stories about everybody. This person was, in my view, weaponized to start a campaign which involved even a what is this thing, a criminal allegation of fraud against me, which was investigated by the SAPS fraud unit, and indeed a determination was made and a nolle prosequi certificate was issued. So this campaign had been ongoing. And I know for a fact that indeed Mkhwanazi was part of this campaign. And I had raised these issues. Unfortunately, I do not have access to my laptop and the likes, but I had raised issues about these things. Now, and that criminal investigation had concluded. After the criminal investigation, that said, all my qualifications and documents are authenticated. You know, I get suspended.
This person, the second last CC'd
Yes.
person, is the one that said you lacked the necessary qualifications?
Yes.
All right, thank you.
And that was investigated. He was the complainant in the criminal investigation, investigated, everything was issued. He even went to the extent of sort of appealing the determination of the NPA. And that matter was then taken to the chief prosecutor, who reviewed the dockets and everything and issued to say, but there is nothing wrong with this person. His qualifications are proper. You know, but then the municipality goes and suspends me using that allegation. So in my view, I mean, they always had the qualifications, you know, so all of a sudden they suspend me saying that I do not have qualifications. And that started another horrendous experience.
Thank you, Chairperson. So, Mr. Ngciza, if I understand you then, even the contents, you know, of what is contained in the pre-suspension notice are, according to you, you know, parts of a broader scheme to protect the brigadier from disciplinary processes and accountability. Is that right?
Yes, ma'am.
Thank you. This then is...
If I may, paragraph 5 of that pre-suspension letter, what is that about? It speaks about a memorandum of 20 July 2023 about invoices, the signing of invoices that you apparently did not comply with. What is that memorandum and what are you supposed to have done?
Madam Commissioner, honestly, I was not even given an opportunity, of course, to respond to this. I actually discovered that indeed such a memorandum had been issued by the HODHR to say to all divisional heads that, remember I spoke about the specimen delegation issue. where she said that, she's holding back the new delegations in terms of specimen signatures and the likes, and effectively barring divisional heads from signing invoices or approving invoices, and there were two invoices that I had signed post the issuance of that memorandum. And quite honestly, my take on it was that I have a delegation from the city manager to deal with invoices of
Thank you, Chairperson. Mr. Ngciza, the look on your... Chairperson, please just give us a few minutes to obtain the witnesses' files. Thank you. Please let me make an inquiry. Security cleared them before lunch. I just want to find out where they are.
Any set too long? Oh, yeah, please.
Thank you, Chairperson. Mr. Ngciza, please confirm then that you've got the two files, your witness statement as well as your annexed bundle.
Yes, I do. I just don't have the other N15 documents.
The extras.
I'm not sure whether we're going to require
I'll provide them to you shortly. One.
Okay.
Thank you.
Thank you, Council.
Thank you, Chairperson. Mr. Ngciza, could I ask you please to turn to page 30 of your witness statement? When we got to lunch, we had concluded the topic before, and we're now beginning a new topic at paragraph 100. The topic is entitled Events Subsequent to My Suspension. Are you there?
Yes, ma'am.
Thank you. Could I ask you to detail to the Commission the contents of paragraph 100? You touched on this issue in your evidence yesterday, and I'd invite you to make any further remarks you wish to make here.
Thank you, Council. Commissioners, on about the 14th of July 2023, a report was generated by the Human Resources Department, an official who is in the office of the HODHR, who was not, in terms of the functional responsibilities in the municipality, necessarily seized with remuneration related duties. This individual is more of support in the office of the HOD. The municipality actually has a unit that deals with the remuneration and benefits that would be seized with reports that pertain to salary adjustments and the likes. However, this specific report was not generated in that unit, but it was generated in the office of Mr. Shega. That report had effectively entailed a salary review for the HODs. I reflect on paragraph 100 that these individuals, on their appointment in March 2023, they were already internal candidates. So they got promoted to the positions of heads of department. They were on the same level as divisional heads. Then they got promoted to the next level, which is HODs, and effectively had received salary increments varying between 200,000 per annum to 300,000 rands per annum. That then happened in March. And then this report that was generated was to effectively then move their packages. If my memory serves me well, I think I can just refer to the actual report so that I give a specific figure.
It's Annex to PN 18, page 341 of your Annex to bundle.
Thank you, Commissioners. The report on 341 then speaks to the adjustments that were proposed. And the adjustments that were proposed were effectively to now move them. I'm just looking for the actual package that they were on. But it was going to move them to the maiden package of 264021. That is on page 343. Their initial package that they were moved from would have been that 2085. So my criticism of this report is that when you actually read the report does not articulate any HR basis for such a salary increase. And I'm saying this because there had not been any evaluation of the functions which would have spoken to a process of job enrichment or job enlargement, which would then invite a consideration of a salary adjustment. The functions that are articulated in the report would have been the functions that the position had at the commencement of the contract in any event. That's one. And if indeed there were such considerations from a human resources point of view, then those considerations should then go to council, because council has approved the positions, and in the approval of the position, the council has articulated what are the functions that are to be performed. And if indeed there is a job enlargement or job enrichment exercise that had occurred, council must be notified so that council indeed approves such. But that did not happen. In any event, I indicated yesterday that such processes of remuneration packages for the municipal manager and managers directly accountable to the municipal manager are regulated by means of the upper limits dispensation that the minister determines. And in terms of that dispensation, at the offer of employment for a head of department or for a municipal manager, considerations about where they shall be put in relation to what is reflected on page 343 in terms of the scale. The scale has got three levels. You've got a minimum package, a median package, and a maximum package. That determination is done at the offer of employment in terms of the gazetted upper limits that the minister would publish every year. Now, when you get to the offer of employment, what would determine whether an HOD is at minimum, median, or maximum would be the results of the competency assessment that would have been conducted. The competency assessments would have 4 outcomes. I heard in some other process that somebody spoke about failing and passing. There is no such thing in competency assessments. There are 4 outcomes. The first outcome is a basic competence. The second outcome is a competent. And then the next one is a advanced competency. And then you've got a superior competency. Now, the regulations say that if indeed an employee gets basic, the municipality is cautioned against employing such a person. But should a municipality employ such a person, that person must be employed with a development plan that would be in place in order for the person to develop the necessary competencies that the better of tests would have proven that this person is lacking in. So you can appoint, but you are cautioned because there are processes that must put in place to develop the competencies of that particular person at such a senior level. Then if you are at a competent outcome, you must then be put on a minimum package. If you're at advanced, then you can be put on a median package. And if you are superior in terms of your competency skills, you can be put at the maximum package. So that is the basis of how the table is translated in terms of its implementation. There is no movement. There is no movement in the levels that is envisaged. There is no, in other HR practices, where there is a salary scale, an employee would have a notch advancement system in place. Here, that does not apply. The only thing that the senior manager would get, on an annual basis, the minister would then make a determination of the cost of living adjustments, which is your salary increase, typically based on a consumer price index basis, the CPI basis. Then that will be implemented to the total cost. And then you'll get that increase like any other employee. Where you are located as per the competence outcomes remains. But this report is a report that says to the municipality, you know what, as much as we were employed at the minimum package, we are still under probation, by the way. However, increase us from that minimum package to the median package. And there is no framework that actually speaks to that. And the report does not deal with how the upper limits are to be implemented as regulated by the minister. So, and the only thing that I could think of having read the report and actually looked at the situation, commissioners, is that these two individuals, and there were other HODs, by the way, that were employed at the same time, and they're not part of the report. You know, that HODs that are employed by the municipality at exactly the same time, but they were not considered in the report. This report sought to only benefit these two individuals who happened to be involved in the Mkwanazi matter only about 2 weeks before the generation of the report. That's number one in terms of your, what you call, paragraph 100. Should I continue? Thank you. In terms of paragraph 101, and I think I need to also answer the question that Commissioner Baloyi raised yesterday. I answered partially the question that was raised about the second leg of the interview process on the appointment and promotion of Brigadier Mkwanazi to Deputy Chief of Police. You are having a situation that defies any HR process that I've ever been involved in. You start off the year having a situation where this employee is facing dismissible offenses and then end the year by promoting that employee. I've not come across that. This was the first time that I actually have come across such a situation. But in relation to how the actual promotion happened, I raised yesterday that I had problems or issues with how the panel was constituted. But there is this other leg that, Madam Commissioner, you raised about the skipping of the second part of the process of appointment. I referred the Commission yesterday to the LAC judgment that dealt with a recruitment process, and I think it is in the bundle, where the municipality went to the LAC and made an argument. In that instance, this employee had failed in the interviews. Having failed in the interviews, the panel said only the people, the two candidates that had passed in the interviews must go for competency assessments. When those two individuals failed the competency assessments, the acting HOD HR and the then city manager concocted an exceptional recruitment process to take people that had failed the interview without even going back to the panel, people that had failed the interview and took them to the competency assessment. And on the basis of an individual passing the competency assessment, there was a proposal to appoint that individual into a position who had failed the interview process. And indeed, we went to the LAC and the LAC agreed that that was wrong. How that entire process was handled was wrong. In this instance, the information that even Chief Mapie testified on talks to, I think it's a flip of that one, where now you have a person who has attended an interview but then doesn't go to competency assessment. And then that person gets promoted without having gone to competency assessments. I have testified that the contractual dispensation that pertains to divisional heads in the city of Ekurhuleni is a dispensation that is akin to the contractual dispensation of heads of departments and the city manager. Everything about their contracts gets reflected into the DH contract, and everything about the recruitment process of HODs gets performed in respect of the appointment of divisional heads. The position of Deputy Chief of Police is equivalent, or is indeed a divisional head level position. And therefore, all divisional head level positions in the municipality since 2003, when it was determined that divisional heads shall have the same contractual dispensation as heads of departments, everybody attends competence assessments. Everybody. It is a policy of the municipality that people must attend competence assessments. And if indeed the allegation that Mr. Mkhwanazi did not attend competence assessment is true, then that recruitment process is fatally flawed, and such a promotion is irregular.
That process of attending a competency, so it's a two-legged process. You have the interview and then you have the competency test.
Yes.
Does it also contemplate that after the competency test, the panel or the committee will reconvene for a purpose, for some purpose, or the decision is finally made by whoever when they get the competency test results?
The policy of the municipality is very clear. An appointment is made on recommendation of the panel. Even the regulations on the appointment and conditions of service of senior managers in local government are very clear. The appointment of a person is made on recommendation of the panel. So you have the first step where you have got the interview. The panel interviews you. Let's say the panel interviews 5 candidates. I'm honestly a bit baffled by the fact that only 2 candidates were interviewed in this particular process. You have an interview of 5 candidates. You then, as a panel, take a view that the 2 top scoring candidates must then go for competence assessment. You have not yet recommended a person. It cannot be that you have recommended, because you can't recommend 2 people for 1 position. So the people go for competence assessment. It should then come back to the panel to say that these people have gone for competence assessment, these are the results. Then the panel must, by way of resolution of the panel, recommend to the appointing authority. If it's the council that is the appointing authority, which will be in the instance of the municipal manager or HODs, then it must recommend, generate a report to council indicating that this is the process that was followed, and therefore this person is now recommended for appointment. If it's a position like the one of a deputy chief of police, the appointing authority, by way of delegation, is the municipal manager. Then the panel must then sit, say these are the results, and therefore of the people that went to the competence assessments, this is the person, given the outcomes of the interview and the competence assessments as a combined process, now are proposing or recommending this individual for appointment.
So do you know how the municipal manager determined that Brigadier Mkhwanazi should be appointed as Deputy Chief of Police? In the absence of the results of the competency assessment and a recommendation from the panel? My engagements with the chairperson of the panel point to the panel said they interviewed, they sent the people to competence assessment. The HR head, Xashega, then submitted a report to Dr. Mashazi. She then appointed Mkhwanazi, and the chairperson of the interview panel, who was Chief Mapieye, then got told post ex facto that there is an appointment that has been made. And that, according to you, is irregular?
That's irregular.
Thank you. Ms. Ngciza, you are still dealing with the contents of paragraph 101, but I would ask you to address the Commission on that 3rd sentence in paragraph 101, starting with the word commissioners.
Yeah, like I had indicated, commissioners, that it's worse because it's still within the same year. We're not talking about some years down the line, and then a person gets promoted after escaping, for lack of a better word, escaping a disciplinary process, on serious allegations. You then have a person going through this funny recruitment process, and then it gets promoted. It's unheard of.
I have never experienced it, you know, to such an extent that the regulations, both the municipal staff regulations, I think, as well as the senior managers' regulations, stemming from, I might be mistaken, but I think it's section 56, capital letter A, or section 50, roundabout section 56 of the Systems Act. The legislature took a view that there must be some prohibition that is put into the legislation on the appointment of people that had been dismissed. You know, and I know COGTA at some point even raised the issue with especially the metropolitan municipalities to say you're having instances where a person gets charged and the person then resigns and then rocks up at another municipality. You know, so they wanted even to regulate that. So there is this emphasis on the need to curb appointment of persons that have been dismissed for serious allegations like gross dishonesty. This individual had allegations of gross dishonesty. Yes, a process was implemented to quash the processing of those allegations, but nonetheless the allegations still remain. They are there, and they have never been disproven. You know, no matter what they did, whatever Mashaz and Klashega and Behari did, those allegations have never been disproven. Then you promote the person. The allegations are still lingering. Whatever they have done, the allegations are still lingering. So that's why, for me, it only honestly sends shivers down my spine, you know, to hear that indeed this person has been promoted in the midst of everything that had happened.
And in the paragraph subsequent to that, you detail some developments as they regard IPID. Can I ask you to address the Commission, starting at paragraph 102, please?
Yes. Recall that earlier in my testimony, Commissioners, I indicated that as much as there was the Erasmus investigation, there was also an IPID investigation into the Blue Lights scandal. Now, it came to my attention that in December 2023, indeed IPID handed their report. For that matter, my briefing was that IPID attempted to give the report even to the Chief of Police, and given what was happening, he advised them to give it to the city manager, but eventually it was given to the executive mayor. And that IPID report had damning findings against Mkhwanazi, and it had directed that an internal disciplinary process be held, and simultaneously it had indicated that it was going to refer the docket to the NPA.
Thank you. And Commissioners, just for reference, the full IPID report is attached as JM19 to the Mapiyeye bundle. And Mr. Ngciza, please then proceed to paragraph 103, please.
Yes. Now, after the IPID report, I came across, and quite honestly, it's funny, Commissioners, because this document was widely circulated by Mkhwanazi, Deputy Chief of Police Mkhwanazi, to politicians that are in the municipality, to say that I was cleared.
And apologies, Mr. Ngciza.
That is on 103.
So that is the document on page 344 of your annexed
Yeah,
bundle.
PN 19.
100, that's correct.
I'm not the only person that got to be in possession of this document, Commissioners. It was widely circulated within the municipality. And what is on PN 19, in essence, firstly, it was not signed by Advocate Behari. It's one of the many funny things that happens in the municipality when crucial decisions are taken. The incumbent of the position is not there. It's an acting person that signs. His subordinates signed it. There was a person who was acting in his position, and another person was a senior legal advisor at the time. They are the ones that purportedly crafted the letter and signed it. Firstly, the letter disagrees with the findings of IPID relating to corruption and fraud that IPID had concluded against Mkhwanazi. Now, in the absence of any new investigation or new evidence, the letter from these individuals rejects the outcome of the IPID report and says that IPID made material omissions and did not thoroughly investigate. In sum, the city, despite possessing an investigation report to the contrary, makes a finding that, or rather, makes a submission that the IPID findings are incorrect. And now, my problem with this the report or the letter on PN 19 is a letter from the legal department. My expectation of a legal department communication to an agency of the state on a matter that falls within the legal ambit of that state agency, that if indeed you are to write such a letter and advance an argument to the effect that that state agency is wrong, you must rely on council resolutions that you would say, sorry, state agency, your findings against us are wrong because what our employee did is informed by this resolution of the municipality. You must rely on a council policy. You must be able to say, in terms of council policy that was adopted as per this item of the municipality, your findings are wrong because our employee conducted himself in line with the provisions of this policy. You must, as a legal department, commissioners, as a legal department, postulate a view that says, in terms of these laws, this employee that you are saying is corrupt and has conducted himself in a fraudulent manner is covered, his actions are covered in terms of this law. You can read this letter. This letter regurgitates the views that were expressed by Christine that we discussed yesterday on the norm that Christine says was done. You take, for instance, paragraph 5 on 345, where the individuals from the legal department say the registration of the vehicles was not done by the suspect, but by the authorized personnel from Fleet. Steyn says clearly in his letter, Mkhwanazi came, Mkhwanazi provided a donation letter. Mkhwanazi this, I facilitated the registration of these vehicles on the basis of Mkhwanazi. But the legal department says, therefore, Mkhwanazi is not, the finding against Mkhwanazi is wrong.
If I may ask, Mr. Ngciza, you say in paragraph 103 of your statement, there's a sentence there, it's the third sentence, where you say, in the absence of any new investigation or new evidence, the letter rejects the outcome of the IPID investigation. Do you see that?
Yes.
Okay. Can I ask you to turn to page 344 of the letter? Page 344.
Yes.
The last sentence in paragraph 2.
Yes.
Could you read that sentence, please?
It says, I have consulted with internal staff and I'm advised that based on the current evidence, it will be difficult to prove fraud and corruption.
Please comment on the rejection of an external report provided by IPID based on consultation with internal staff, if you have any views on that.
Firstly, it's the internal staff that are supposedly consulted. Commissioners are not listed. They are not listed. The reference in the letter to Steyn talks to the letter that Steyn, the statement that Steyn made in March 2023, which was part of the docket, and indeed, to simply say that they consulted without even indicating who they consulted also doesn't make sense.
Mr. Ngciza, you keep saying they, but the author of this document says I. Paragraph 1, I refer to your memorandum. Paragraph 2, I have considered the matter.
Yes.
The paragraph you have just read, last sentence, I have consulted with internal staff. I am advised that based on this and this and that. And then throughout the document it says that I. Do you know who the author of this document is?
On page 348.
No, because there are two people who have signed, but it's clear from reading this that only one person authored. It's not clear whether the acting HOD simply endorsed the letter or whether he is the author of the letter. So it's really not clear who authored and who made the investigation and who consulted with internal staff.
And that's why, Commissioner, I refer to they.
It does not say we.
Yes.
Because if it said we, then you could say they.
It's difficult for me to say who.
Yeah.
Because, firstly, I had indicated to commissioners that, let's say if we go to page 344, at the commencement of the letter, how we write letters, we would have an inquiries person. You look at even the letter that was dated the 22nd of August, signed by the city manager, but we've got an inquiries person. Then it tells me that the person who would have been the author, even though the person who owns the document is the city manager, but the author would have been this person. So in this instance, you've got two people that have signed, and it's not even clear exactly who amongst the two people is the author. But for purpose of a hierarchical ownership, let's call it a hierarchical ownership, I would say then the acting HOD as the last signature, because the senior legal advisor the legal advisor is the junior person to the acting HOD. So I would assume, Commissioner, if I was to use a singular person, I would say the I would refer to the acting HOD. But it's not apparent from how they've crafted the letter. But if indeed there is to be accountability for this letter, in my view, both of them have to account.
Mr. Ngciza, if I can take you back where you were. You were on page 345 of the letter, and you were dealing with the issue of donation under paragraph 5.
Yes.
But I would like to, still on the issue of donations and the response provided by Mr. Chris Steyn from Fleet, I'd ask you to turn the page to 346, at the top of the page. Do you see the sentence beginning with the inverted commas? Did you then consider?
You see, and again, commissioners, maybe my approach to compliance issues might be different from the people at the legal department. But you don't take a view that there was nothing wrong that the employee did because you are saying to an investigating authority, did you consider that all other donations in AMPD were also non-compliant with the process that you described? And surely Chief of Police and other senior management, including Deputy Chief Spies, who has lodged this complaint, cannot be ignorant of such donations. Let's assume that indeed they were not compliant. Does that mean, therefore, this one that is also non-compliant must be let go? Because that is the suggestion that I read from this,
Please continue in that paragraph.
Minister is, furthermore, according to Steyn, the EMPD was under-resourced at the time. The Chief of Police, my PA, and Deputy Chief Spies addressed this to effectively and efficiently protect the residents of the city of Ekurhuleni. My God. I'm sorry. We don't write like this as management. We simply don't. This is not a management thought process, let alone a legal department thought process. This is not about protecting the interests of the municipality. I indicated yesterday that if indeed there was a scarcity of resources, there should be a report that is generated. There's a report that must be generated. If there's a scarcity in Kwanazi's division or unit, my expectation is that as a manager here generates a report, which report at the end of the day, if we are going to go out and source donations, is there to say that indeed there is an acknowledgement by the institution, not by Steyn. Not by Steyn. And they are raising these questions as if now they are saying, if indeed there is anything wrong that has happened, it's Chief Mapia and Chief Spies that have done something wrong.
Ngciza, you say management doesn't write this way. At page 348, we do have the names of the people, and you say the letter is widely circulated. The one is Advocate Njabulo Zulu, legal advisor. The other is Thabo Makwiting, acting HOD, Corporate Legal Services, and both their dates are the 13th of December 2023. Apart from, we don't know who is the I that is referred to unless Zulu and Makwiting make one person, and therefore that I. Are these people even legally qualified? Are they employees of the city? I'm asking in all seriousness because this is a nonsense document when you read it. It's bad, and I'm hoping that we can cut through this and just get straight to what this is. Are these people employees of the city, and are they in the legal department? Do they hold degrees, law degrees to qualify them for those positions? Do you know?
Thank you, Madam Commissioner. Yes, Madam Commissioner, these are employees of the municipality employed in the legal department. Advocate Njabulo Zulu, now that you've mentioned the name. Okay, thank you.
These are public officials in a government institution, and there's nothing wrong in mentioning who wrote the letter.
Thank you, Madam Commissioner.
Advocate Njabulo Zulu, in my understanding, is an advocate of the High Court. Before joining the municipality, I'm aware that he was a prosecutor at some point in the National Prosecution Authority. I think possibly he has less than 10 years in the service of the municipality. He has recently been appointed to divisional head position. After this, I think sometime early last year, he was appointed. This was in December 2013, he was a legal advisor, and then sometime last year, he was appointed to divisional head. It's called Specialized Legal Services. And then Thabo Makwiting was a legal advisor in the municipality until October 2023, whereat he was promoted to the position of divisional head. I'm not sure exactly what is he responsible for, but when he signed this letter, he was 2 months in the position of divisional head. If we were to ask me, Commissioner, what are my thoughts about this letter? My first thought about the letter is that they are not the authors of the letter. My first thought.
Why do you say that, and who do you think authored the letter?
I say that because they were not involved with anything that concerned the Mkonazi debacle. It is Advocate Kemi Behar who was involved with the Mkonazi debacle. I believe that the letter was prepared, whether they were involved or not, but Advocate Behar would have known about the letter and the preparation of the letter. I believe that then he would have taken leave, and then indeed these two would have signed the letter on his instructions.
In fairness to them, let me just mention part of why I say this is a nonsense document, or it doesn't make sense, at least let me say, is if you look at 346, paragraph 6, this is about the vehicle registrations, and it says at the time of vehicle registration, the benefit would have accrued to the city had the deal been approved. So there is an acknowledgement that there was no approval, right, of the transaction. And then 2, it says the costs incurred in the registration of vehicles was a step towards obtaining the benefit on behalf of the city, right? Mm-hmm. And then you then further go on to, and so it says, let me finish off that paragraph. It will be challenging to argue that the registration costs constitute prejudice to the city. But right, we know that that was reversed, right? That registration. The registration cost should not be viewed in isolation, but as part of an entire process. And then if you go to paragraph 8, it says, the vehicles were not registered fraudulently as explained above. It is difficult to see how CAT benefited from the registration of the vehicles as they transferred ownership to the city.
Sorry.
We know that's not true, right?
And that's the problem I
They
have.
were never transferred to the
Commissioner.
city.
There was never a transfer.
Okay.
There was never a benefit that accrued to the city at any given point.
Yes.
Even the paragraph 6 that Madam Commissioner was reading, at the time of vehicle registration, because by the time you register the vehicle, the ownership must have transferred. You start first with the ownership before I register the vehicle on the system. We deal with the issue of ownership, you know.
Yes.
If indeed there is a donation of a vehicle, before we go and run and register this vehicle, I must first have the ownership of the vehicle. We must deal with whatever transaction that must be entered into, where indeed you transfer the ownership to me and then we register the vehicle on the system. Yes. The registration thing is a system thing, but the actual transference of ownership has not happened at any given point. You know, and that is the nub of this problem. There was never, because the processes, and it's worse, a legal department effectively says indeed there was no compliance with the policies of the municipality.
Yes.
They agree in paragraph 7. Failure to comply with internal policies relating to donations does not translate to fraud.
Yes.
So there is a failure to comply with internal policies. So even if it does not translate to fraud, let's give them that it does not translate to fraud, but it translates to misconduct. It translates whether they were negligent in terms of their non-compliance with the policies, or they were dishonest in not complying with the policies. But there is a clear misconduct with non-compliance with policies. Now, if a legal department will write something like this, and then tomorrow we want to go and discipline employees for non-compliance with policies,
Yes.
I mean, our employees will just simply say, but why does HR want to discipline me when the legal department actually doesn't find anything wrong with non-compliance to policies? They even wrote a letter to IPID, a legislated body that conducts investigations, that, you know what, your finding of non-compliance to policies is irrelevant. You know, that's why, I call this a funny letter. You know, I heard Madam Commissioner even using a nicer word of a nonsensical letter. You know, but what does this mean, therefore? And I think the point that I wanted to raise with the Commission, Council, if I'm allowed, the way that this letter is crafted as a defense letter. This letter is crafted to say, you know what, IPID, leave Julius alone. This letter resonates with what happened in the telephone call of the 23rd of May, 2023. In the telephone call, I was instructed, Mutluhele Julius, leave him alone. In this letter, the essence of what is here is to tell IPID, leave Julius alone. He has done nothing wrong. Actually, if there is anybody that must be looked at, is to look at the Fleet Management Department, you must look at my PAA, you must look at SPIS. Look at everybody else. Leave Julius alone.
Maybe finally, the letter says 347, at page 347, paragraph 11, it says respectfully the suggestions, and I underline suggestions, of IPID, given such material omissions and failure to thoroughly investigate the risks the city in any further processes herein. And then 12 says, please respond within the next 10 days. Now, the report that we have seen, and if you are aware of another report from IPID, this is your chance to say. The report that we have seen doesn't contain suggestions. It contains findings and a recommendation to act. So are you aware of another report that contains suggestions that can be responded to?
Madam Commissioner, in my history, I've never come across an IPID report that is suggestions. I've never. A suggestion is to say change the way you're doing things and do them this way. IPID is not that type of an institution. They would not have authority to make suggestions to a municipality.
There's no way that they could have, the author of this letter could have misunderstood that IPID was making suggestions, at least on the report that we saw. It makes findings and recommendations of what action must be taken.
I'm trying to look for the right English word, but the closer response would be bayageza, sisgeza, nento abayenzayo. I'm not sure would the right English word be they were silly. They were just being silly. Because to take it further, that paragraph 11 talks about the failure to thoroughly investigate risks the city in any further processes herein. IPID says discipline. Discipline. That's all. And I don't know why people are so scared about discipline. You know, discipline, it's a normal process of an employment contract or of an employment relationship. Subject an employee to discipline where there are questions about the employee's conduct. That's all. Let the employee go and respond.
let it be Mkhwanazi that goes and says, you know what, there is nothing wrong. We've been doing this with my PA and peace. That's my expectation. It must be Mkhwanazi who leads that evidence in the disciplinary inquiry. He's the one that must go and tell the chairperson of the disciplinary inquiry that what is being raised with me is inconsistent with the conduct of the department, not the legal department raising that. So what would come out of a disciplinary process that risks the seat is that Mkhwanazi gets dismissed and Mkhwanazi institutes an unfair dismissal dispute. So we go and defend it.
Thank you.
There's no risk.
Thank you, Mr. Ngciza.
And just to close on this, commissioners, to me, this letter on all fours is a letter that at page 348, the person who would have written this letter, all things being equal, would have been the regional secretary of the trade union. The person who would have signed here, given the content of the letter, you know, a regional secretary of a trade union would be raising all these issues to say, you are wrong, employer, you can't do this way, our member this, our member that. This is what this means to me. These people were just shop stewards of Mkhwanazi.
Thank you, Commissioner. Mr. Ngciza, in light of those remarks in respect of IPID, I would then ask you to turn the page to page 32. You are on paragraph 104, please. 104.
Yes. Yes, thank you, commissioners. 104, I wanted to inform the commission that on the, actually it's not the 8th, it's the 22nd of March. It's just that the letter is dated the 8th, but the actual service of the letter was on the 22nd of March. And my understanding of labor law is that a termination of employment occurs upon service of the termination on the employee, not on the date that the letter is dated, because there cannot be a retrospective termination of employment. So if I may correct, the letter is dated the 8th, but the actual service of the letter via a firm of attorneys occurred on the 22nd of March 2024, and therefore my 26 years of service in the municipality was summarily terminated on that date.
It's actually dated the 7th, but it says the effective date of termination is the 8th.
Yes. That is the supposed date that the letter was signed on. And I would say it's supposed date,
The next page, yeah.
Commissioner, because on the 8th I was called, and there's an area where I actually tabulate my experiences. I was called by an inspector, I think it was de Villiers, who requested that indeed I must meet him at my offices. I must bring the office keys and I must send them over, and I must take possession of a letter. When I got there, the letter was not signed. That was on the 8th. Hence I say the supposed signing date was supposedly the 8th. But on the 8th, the letter was not signed. And de Villiers went around looking for the acting city manager and they couldn't find him. And then eventually, after about 2:02 in the afternoon, they indicated that, you know what, we can't find this gentleman, so the letter cannot be signed. When the letter gets signed, we'll indicate to you. And then 2 weeks down the line, I received the letter that was signed, dated the 8th, after 2 weeks. So that's why I'm saying it was supposedly signed on the 8th. But what is worse is the fact that the person who signed the letter on page 250 as acting city manager, because we've got an arbitration that is running on this particular issue since last year. The person who signed the letter, we discovered that his acting was from the 26th of February to the 1st of March. So by the time the person signed, he was no longer acting.
That's the niceties of this place. But nonetheless, I was terminated summarily without a disciplinary hearing. There was an attempt to have a disciplinary hearing. At the disciplinary hearing, the presiding officer had made a ruling that if I had points in limine that I wanted to raise, I must raise them within a specific time period. I did raise my points in limine. The municipality was not able to respond to the points in limine. And I must say, in my view and my rep's view, the points in limine that we had raised were dispositive of the matter. But the legal representatives of the municipality, which was an attorney and an advocate, also admitted on the 26th of February that, Mr. Ngciza, if these issues are not responded to appropriately in terms of historical analysis of contracts of employment, then this would be dispositive of the matter if the municipality is not able to respond.
Just, Mr. Ngciza, for me to understand the timeline, what happened first?
Okay.
Between the letter we are looking at, that's PN 20, and what you refer as an attempt at a disciplinary process. Okay. What happened first? All because right. This letter does not, I hope I've read it correctly, it does not seem to refer to any disciplinary process. It just said, we called upon you to give us documents proving your legal qualifications. You failed to do so, you are terminated. Yeah. So, yeah, just the time, what happened first?
What happened? Mr. Chair, I was suspended effectively on the 7th of September, because even the representations on the suspension, when, I raised issues, they didn't consider them. I was suspended on the 7th. I was then served with a charge sheet, and there's a table where I articulate how our service was done on me. I will come to that. I was served with a charge sheet on the 23rd of January, and then we had a disciplinary hearing on the 26th of February. In between, there were all sorts of exchanges, and then the presiding officer was appointed, was an attorney, ruled that we must submit points in limine. I was supposed to submit my points in limine by the 23rd of February, which was on a Friday, and the employer was to respond on the points in limine by 5 o'clock on the 25th of February, which was on a Sunday. And then the chairperson was to make a ruling on the 26th, the Monday morning. And then we were to sit for the disciplinary hearing on the 26th and the 27th of February. I made my submission. The employer, instead of responding to the points in limine, sent an email on the Sunday. And in the email, firstly, they suggested that I had waived my right to raise points in limine, even though there was a ruling by the chairperson. But nonetheless, they said I had raised issues about contractual dispensations, and their client, which is the municipality, was not aware of these things, so they are not able to respond. We met on the 26th, which is the Monday. When we met, we dealt with the issue of the points in limine. The chairperson requested me to assist the employer with retrieving the council resolutions that I had submitted in my points in limine. There was a 2003 council resolution, and there was a 2011 council resolution. I then assisted them, went into the system of the municipality, and we did get the council resolutions. The prosecutor, the advocate, I'm not sure whether I should have mentioned names, but the advocate that was dealing with the matter then raised an issue to say these resolutions make reference to reports, and there's a need for them to get the reports. So we tried to get the reports on that morning. Then there was an agreement that no, these reports are not on the system of the municipality, on the intranet. So they are archived off-site We are in Germiston, they are archived in Birchley, Kempton Park, where there's a major archive center for the municipality. Then the municipality would go and retrieve the reports, which of course were named in the council resolution. They'll retrieve the reports, and then we should postpone the hearing to the 20th of March. All nice and nice. We agreed. The matter gets postponed. On the 1st of March, which is the Friday, this was a Monday, on the Friday, I received a letter from the municipality. I get accused in that letter that I have delayed the dismally hearing by raising points in limine. And therefore the municipality has taken the decision to put the dismally hearing in abeyance. And I must give them reasons why I should not be terminated. They list their issues about even the criminal case that I referred to earlier on. They list the issues about my advanced labor law program. And I said, fine, no problem. I'm called upon to make submissions by the 5th of March. I made the submissions. The total submissions that I made, commissioners, was 64 pages. I did a thorough, comprehensive, articulation of the issues, but then also had annexures, that even talked to what the university had provided. They did not have a problem with my law degree. They just had a problem with my advanced labor law program from UNISA. So I gave them everything that they required, in my view. Gave them everything that they required. And then on the 8th, I gave them on Tuesday the 5th. On the 8th, there was this attempt to serve me with this letter. When I took the letter, I noticed that the letter was not signed. And therefore the employee who was serving me with the letter had to go back and get the letter signed. They failed to have the letter signed on the 8th. We proceeded, because now I was not served with a termination letter, and in our understanding, the matter has not been withdrawn. The matter is still scheduled for the 20th. On the 19th, my representative sent them an email to say that the matter is proceeding tomorrow and the likes, and the attorney then responded to say, no, the 20th was a provisional date. All of a sudden now it was a provisional date, so we're going to revert to you. And then the next morning they reverted and said, no, the matter is not proceeding. Well, the matter did not proceed. And then on the 22nd, another firm of attorneys that was not part of the prosecution, but a firm of attorneys that was part of my unfair labor practice dispute on the suspension, then served me with the dismissal letter, this letter. And this letter is, of course, the subject of unfair dismissal proceedings that have been ongoing since March 2024. And I'm still busy with my unfair suspension proceedings that have been ongoing since September 2023.
Thank you.
Thank you, Chairperson.
Mr. Ngciza, this process, this shorthand process where you are called upon to make representations why you should not be dismissed, and then a decision is made on that basis to terminate you, is that provided for? Is it something that is regulated by the collective agreement?
Not at all, Madam Commissioner. What they said in their letter dated the 1st of March, they invoked Schedule 8, Item 4, Sub-Item 4, which speaks to, I think the provision is crafted might not be able to quote it verbatim, but it says in exceptional circumstances where an employer cannot be expected to follow the pre-dismissal procedures, the employer can summarily terminate the services of an employee. And I think it's a provision that I think our courts have said can be invoked in what would be regarded as war zone circumstances, like industrial action where, you know, the situation is beyond. They invoked that. They said it's exceptional circumstances. The fact that I raised points in limine. But well, it's just one of those.
All right, thank you.
Do you still have a copy of the 1st of March 2024 letter?
I have a copy of that letter, but it's not here. I have a copy of the letter. I think we can
Make it available.
We can make it available as well as the representations that were made.
Because reading the 8 March letter on its own doesn't tell the full story.
Especially when you read that I have considered, I have perused and considered your representations, and that's it. Yeah, but I think can make them available.
We'll obtain a copy of that letter, Commissioner Kumar. Mr. Ngciza, that then brings us to paragraph 105. You're on page 32, paragraph 105.
Yes.
Indeed. Please inform the Commission about your receipt of the report.
Yes,
cited
Commissioners.
there.
In October 2024, I was forwarded a report that is titled Forensic Investigation Report into Allegations of Defamatory Statements Made Against the City, Breaches of the Protection of Personal Information Act, and irregularities relating to the engagement and payment to attorneys, and the name of the attorneys, in and about May to August 2023. That was forwarded to me by Chief Mapie.
That report is, you'd find it on page 351 of your annexure bundle. If I can assist you, Mr. Ngciza, you can also also have regard to page 370 as you deal with paragraph 107. So page 370 can assist you in giving evidence as it relates to 107.
Yes. Commissioners, at the offset, I need to indicate that, again, this is unheard of. This was unheard of. On 2 counts. Firstly, I still even have in my phone all sorts of issues that have been raised in the life of this municipality about officials in the municipality, both on social media, in newspaper articles, things that have been sent to journalists concerning employees of the municipality, inclusive of Dr. Mashaz. There is a point where there were such gross allegations that were made about corruption, tender irregularities, and all sorts of things. Beneficiation of employees and senior managers of the municipality in terms of their association with politicians, with service providers, and all sorts of things. Very, very gory things that have been said about
all sorts of employees in the municipality. At no point whatsoever has the municipality ever commissioned a forensic investigation. Never. On another point, we've had instances where we would have investigations conducted, would have determinations made. Some determinations are made without even an investigation, and decisions will be taken that, you know what, we do not have a strong case, properly taken, that there's no strong case to pursue a particular cause of action. No problem, And even if you had attorneys appointed to assist the municipality in making those determinations, that has happened long before even Dr. Mashazi was a city manager. This report seeks to firstly say that there is an investigation that is conducted because of some remarks that are associated with the Beatley emails, the 20 August 2023 email and the 2nd September 2023 email, number one. It seeks to investigate that, who is Beatley and all sorts of things, and whether indeed the remarks that have been made by Beatley are defamatory or not. That's what that's how they've characterized the investigation. And it makes that finding that they were defamatory. However, we don't know who's Beatley. They can't find who's Beatley. But also then it goes to the dismally hearing. And it makes all sorts of findings about the dismally hearing. But key amongst the findings that it makes about the dismally hearing is...
Let me assist you, Mr. Ngciza.
Yes.
If you turn to page 391, 391. 391.
91.
Yes, 391 is where the heading conclusions begins.
I don't have on this bunch.
In the annexure bundle?
I don't have, unless, remember, this is not my original annexure bundle.
Let me, give me a few minutes, let me address.
Yeah.
Don't you have who's also do you have one for yourself?
Yes, I'm in order, Chairperson. We had a spare and our attorneys are providing it to the witness. Page 391.
I'm there.
Thank you. The top of the page is titled Conclusion, addressing the Commission as regards to allegation number 3. So please just turn to page 392, allegation number 3.
Thank you. And I think, commissioners, you would have a better appreciation of the folly that exists in this report, having had the discussions that we did regarding the appointment process in terms of the disciplinary procedure collective agreement. On paragraph 13.7, it says, Ngciza had, by appointing those attorneys as the city's legal representative in the Mkhwanazi disciplinary matter, without having obtained Mkhwanazi's prior written consent, breached the clause 774. And when you read the clause itself that they have quoted, it doesn't say that there must be consent. It says there must be agreement as the first option. But it goes on, after saying that
unless both parties agree in writing to allow legal representation, or if the presiding officer, upon receiving an application by any party, determines that it is reasonable to allow legal representation, having regard to the applicable criterion. Now, there is no requirement that must get consent. It says get agreement. If you don't get agreement, apply for legal representation. This clause, commissioners, when we negotiated, and fortunately I was part of the negotiators, we took this clause verbatim from the Rule 25 of the CCMA. You know, it's exactly like that. Either parties shall agree or there shall be an application. So it's not saying that you get consent, but most importantly, you would not know whether indeed you are to engage with the employee before you serve the charge. I don't know whether I'm making myself clear. The way that things are done, you appoint a presiding officer and a prosecutor. The prosecutor will craft the charges. Having crafted the charges, then we serve the employee with the charges. The employee, having received the charges, would make a determination on how he wants to respond to the charges. Firstly, do I, as an employee, want to represent myself in a matter of this nature, given the type of charges that have been leveled against me? Do I want a shop steward or trade union organizer or official to represent me in a matter of this nature? Or alternatively, am I going to source legal representation? You know. Now, then those are the options that are open to me as an employee. If, having due regard to the type of charges, I take a view that I'm going to sort legal representation, then when the employer comes to me and says, listen, I've got a legal representative, I want us to engage on representation. You know, as the employee, I am better positioned to apply my mind on the provisions of 77.4 in respect of whether indeed I agree to legal representation. And if I don't agree to legal representation, it doesn't mean that the employer cannot be legally represented. You know, it doesn't mean that. I might say I don't agree, so fine, I don't agree, then the employer must go and apply in terms of this clause. But this person that was doing this investigation, even though clause 774 is clear, he even quotes it. He then says, no, but you've breached this because you didn't get the consent of Buchanas. If indeed employers are to get consents of employees, then they will never have legal representation. And there is a point, commissioners, where indeed our collective agreement outlawed legal representation. You know, there is a point where indeed we had said as the parties in the bargaining council, no legal representation whatsoever. But then in 2018 we brought it back because of our experiences in disciplinary inquiries, especially disciplinary inquiries of very serious and complex misconduct proceedings. And it was agreed that we are going to use the CCMA rule and convert it into a provision in the DPCA. So this is just...
If this disciplinary process had not been terminated prematurely, how would this have unfolded to get to a point where legal representation was allowed?
All right. Firstly, let me make the point that clause 7.6, this is 7.7 that talks to legal representation for employer representative, the prosecutor. But 7.6 does not talk to legal representation in respect of the presiding officer. Okay, so you can appoint an attorney to be a presiding officer. There is no application that is required there. There is no agreement that is envisaged.
Let's just zoom in on 77.4.
Yes.
which I understand to be about legal representation for the employer or the
Or
employee.
Exactly.
So how would that have unfolded to get to a situation where there would be legal representation as envisaged?
Now, what would happen and what happens in practice is that we appoint a prosecutor. If I appoint a firm of attorneys to prosecute, because I have to appoint them, the prosecutor must generate the charge sheet, no one else. The prosecutor that is appointed is the only person that is empowered to actually say this is the charge sheet. So I can't draft a charge sheet and then after having drafted the charge sheet, serve the charge sheet on the employee, then appoint. It cannot happen that way. So we appoint, the prosecutor drafts the charge sheet, we serve the charge sheet. The employee then, even in the charge sheet, we mention that you have a right to have legal representation. So if the employee gets legal representation, it makes life easier then, because then it's easy, both of us are legally represented, we get the agreement, we even submit it in writing that the parties have agreed and that's it. Or the employee goes to his trade union, and the trade union can also agree that it's fine, employer can be legally represented, no problem. But where the employee says, no, I'm not agreeing to legal representation, then we make the application to the presiding officer. It is then the presiding officer, having followed the criterion that is enumerated in the collective agreement, he will then make the determination that indeed legal representation is allowed or not. If he makes a determination that it is allowed, the process continues. If he makes a determination that it is not allowed, then the process comes back to me to then make an appointment of a suitably qualified person, either in the municipality or outside of the municipality from another municipality.
So
that's how we do it.
all right. At which point, though, leave out the stage of the preparation of the charge sheet and so on, I want you to address us closer to the stage of the actual hearing. At which stage would the employee and employer have engaged each other with a view to reaching agreement or not reaching agreement on legal representation?
What we normally do, commissioners, is that we first appoint a prosecutor and then we engage the employee at the point of we serve, then we engage the employee after serving the charges.
So it would have been at some point before the hearing.
It
would have been at some point before the hearing.
Before the hearing, yes.
Okay.
After the service, then we engage to say that, for instance, in the charge sheet, it would reflect who's the prosecutor in the charge sheet. And then the employee would know that the employer has appointed a legal representative in the charge sheet, And then we, because from the service of the charge sheet to the sitting of the hearing, there are timelines. So in that process, we get into this engagement with the employee. In most cases in the municipalities, the employee would have a trade union. I mean, in Ekurhuleni, close to about 95% of employees are trade union members. So you would then have, the employee would, sometimes you serve the employee, you also copy the trade union, the charge sheet where we've got the employee's trade union details on file. Then we are able to serve the trade union as well.
Mr. Ngciza,
Thank you.
and just perhaps to assist in tying up your answer to the chairperson, if you have a look at page 295 of the annexure bundle 295. Under the heading there, the employee's rights, 295, yes.
Should I read them?
You're entitled to, if yes.
Thank you. Commissioners, this is the charge sheet for Julius Mkwanazi as reflected on page 292. 295 refers to the rights. The first right is the issue of representation. The employee will be entitled to be represented at the disciplinary inquiry by
Bullet 1, a fellow employee of his or her choice from within the employer, or any member, office bearer or official, or the employee's registered trade union, or a practicing attorney or a practicing advocate of the High Court, or both. So
And
the employee has that right if he elects to use the right to legal representation. We don't have a problem as the employer.
And if you turn the page to 296, please. The page 296, the second paragraph starting, please take notice. Please take further
Yes.
notice.
Please take further notice that the employer appointed Mr. blah blah attorneys who have subsequently briefed blah blah advocate to initiate these disciplinary proceedings against the employee. The employer will accordingly accept service of any correspondence or process at the following address. And it lists the address of the attorneys.
Thank you. Mr.
So that effectively, firstly, gives the employee the rights, but second and most importantly, in the charge sheet, we always demonstrate as the employer who is going to be the prosecutor, and if indeed the employee then having regard to such, in practice, commissioners, employees would then also revert to the employer to say, okay, here's my rep, if it's a legal rep, these are the people that will represent me, is my trade union, and we take the process forward. We have those engagements. If indeed there's an agreement, when we go to the disciplinary hearing, as it was envisaged there, to take place on the 3rd of July, by the 3rd of July, if indeed Mr. Mkonazi would have appointed an attorney, which was within his rights, we would have then gone there to indicate that here is a written agreement between the parties, both of them are legally represented, or for that matter, you could have had a trade union rep who says, I don't care that the employer is represented by a trade union, it's not a problem. I mean, a legal rep, it's not a problem for us. It has happened as well.
But isn't there a problem with this formulation? Take an employee who is not in the know or who knows nothing at all about disciplinary processes and the prescripts applicable to such processes. That employee would not know that there is a clause 7.7.4 which says neither party can have legal representation unless there's agreement. So what your formulation or the formulation that we've just gone through now just says you are entitled to be legally represented. The municipality is already represented, and there is no indication at all that there's something like clause 7.4, 7.7.4.
Okay. Now, remember, commissioners, even if indeed you are seized with a situation where the employee is not au fait with the provisions of the collective agreement, the collective agreement says if there is no agreement between the parties, the employer then must apply to the presiding officer.
It's exactly my point. Exactly my point. The employee will not even know that there's such a process. The employee will proceed on the basis that my employer has told me that I have a right to legal representation. Mm-hmm. Let me seek legal representation. So the employee will not know that I can actually say, I do not agree that any of us should have legal representation, as I'm entitled to say so in terms of clause 7.7.4. So for that reason, unless you say something that I understand, your formulation is incorrect. You simply say you have a right to legal representation, and we as the municipality are already exercising a right to legal representation. Mm-hmm. That does not speak to clause 7.7.4. Do you follow my
I follow point? You, Chair, I follow you, but let me put it this way, Chair. Firstly, every time we have a collective agreement, employees in the municipality are orientated on it. That's the first point. The second point is that in most instances, almost 100%
of instances where we appoint legal representatives, it's for senior employees, because if indeed we are talking about employees that would not be au fait with the policy regime of the municipality, because this becomes a policy regime of the municipality, the collective agreement, that would in most cases be with your lower level employees, and unless there is something exceptional about that misconduct, we would not use legal representation for that level of employees. But we are talking here in this specific instance, a very senior employee, number one, and indeed they would know because we do a lot of workshops on the collective agreement. We even had a program where we did depot workshops. We went through all the depots and had workshops with employees so that employees know their rights, know the processes that apply to them in respect of what happens, in respect of discipline management, grievance handling, benefits administration and all sorts of things. So we put a lot of emphasis on getting employees to understand the rules in the company, Now, I understand where you're coming from, Chair, but in practice, this is what we've done, and we've done, and not only ourselves, almost all the municipalities that I'm in contact with. This is how we do it. We appoint the prosecutor who crafts the charge sheet. Having crafted the charge sheet, remember, before the service of the charge sheet, the employee is not, in essence, aware of being summoned into a disciplinary hearing. So it is the charge sheet that effectively hits the employee to say, by the way, now I'm required to interact with the employer in this particular process. So, and the person that must craft the charge sheet is the prosecutor. So, and my colleagues in the sector would say the same thing. That is how we do it. We appoint the prosecutor drafts, then indeed. The safeguard that I think the clause puts in place for the employee is that in the absence of that agreement, remember, it's not automatic that even the attorney that I've appointed is admitted into the disciplinary hearing. It's not automatic. The presiding officer still has to make a determination. And that if the presiding officer having due regard to the factors that are listed in 7.7.4 makes a determination that no. You know what, this is, you're going overboard by appointing legal representatives. The chairperson, and it has happened, the chairperson would say, this matter is not that complex, this person is not that senior, you do have suitably qualified people that can deal with this. And indeed, if the chairperson makes that ruling, safeguarding, of course, also the interests of the employee in this particular regard, who would not have been au fait with the processes, which is very, very minimal in our situation. Then the employee, the employer would then do away with legal representation and appoint a suitably qualified internal prosecutor. That is how it has played out all along, Chair.
I don't want to belabor the point. In your introductory remarks in responding to my question, you emphasized the level of the employee or employees. My question is less about that. It is more about the prescript. Because the prescript says there must first be agreement, failing which there must be an application. So this proceeds from your formulation, proceeds from a premise that already says you are free to get legal representation. It says nothing about you are free to refuse or not to agree that either of us should have legal representation. But as I say, I don't want to belabor the point. You've given your response. Thank you.
Thank you, Chairperson. Mr. Ngciza, you've had an exchange with the Commission regarding the findings summarized in paragraph 109.1 of your statement. 109.1 on page 33.
Yes.
Yes. With regard to the actual report, as it's set out on page 393, I would ask you to comment to the Commission in light of the contents of paragraph 109.2. Do you see that?
At 110?
Paragraph 109.2.
Yes.
Thank you.
Now, this finding that was made is linked to the one that says that I should have gotten prior consent before appointing the what you call the attorneys to prosecute. And unfortunately, again, it talks to how we have always interpreted this particular provision. And quite honestly, we have never actually even received a challenge that our appointment of attorneys was incorrect, and the manner in which we've appointed them, even in terms of unfair dismissal disputes that were handled by attorneys in the municipality and elsewhere. So this one then says, because we have appointed those attorneys without having received prior consent from the employee, therefore, you know, the monies, because the attorneys then submitted an invoice to the effect that certain fees were owed for the services that they rendered, the attorneys as well as the advocate, and the total value thereof was 45,470. Perhaps one of our biggest challenges, commissioners, and I'm sure that other labor relations practitioners in the sector would also have this view, because that is what we do, is if indeed it is correct that you must first get the consent, remembering that even if you don't get the consent, you can still apply to the presiding officer. So it is not automatic that legal representation is not allowed. You know, so even if indeed there was no consent, the application could still be made to the presiding officer, and that is what we always do. That even if there is no consent, we'll still apply to the presiding officer. It is the presiding officer who is seized with the matter, who then makes a determination on whether indeed legal representation is accepted or not. You know,
for the record, Mr. Ngciza, I don't want you to go home on the understanding that my questions were suggesting that you should not have been assisted by attorneys in formulating the charge sheet, for example. And also, I would imagine that an application failing agreement for legal representation could be made even on the day when the proceedings are to commence. And if that is correct, if that's a correct interpretation, you would obviously be going there with your lawyers ready to run with the process in the event that the application for legal representation is successful. So don't leave this room thinking that I'm saying that you should not have engaged lawyers. I'm by no means suggesting that. It's more just about the formulation of that initial document that I'm saying perhaps there is a need for a reconsideration. That's all.
Okay.
I'm not at all saying. So I'm not saying that there was anything the matter with, for example, having lawyers in respect of whom costs to the, or costs in the amount that has been indicated ought not to have been engaged.
I get you.
Or rather that attorneys should not have been engaged with the result that the indicated costs were then incurred. I'm by no means suggesting that. I'm not there at all.
Thank you, Chair. Thank you, Chair. And I appreciate, Chair, the wisdom that the chairperson is actually sharing on this particular aspect. And I think my colleagues around the country who are observing these proceedings would also, take them to heart, take your wisdom to heart, so that indeed we fine-tune this. We fine-tune this. Thank you, Chair. But the point that I was making, Chair, is that indeed the determination that is then made by the forensic firm to say that it was wasteful expenditure to have appointed the attorneys to deal with this matter is off base, because had Mkhwanazi been charged, that he accepted the charge sheet as per any normal situation in the city, and the matter would have gone to the dismissal hearing on the 3rd of July, and indeed the dismissal hearing would have proceeded. We are confident, and we were confident that even in our application for legal representation would have been successful. But when you read this report suggests, Chair, that there was a withdrawal of the dismissal hearing. And now we have actually dealt with the so-called withdrawal.
If I can
Yes,
assist you, Mr. Ngciza, page 393, paragraph 13.8.3. 13.8.3.
13.8.3. Now, this finding, Chair, that actually wants to say that the expenditure becomes fruitless because there was already a withdrawal. The expenditure is incurred before there was a withdrawal, So it cannot be that the expenditure becomes fruitless because of the withdrawal. Now, and secondly, I still maintain that there was no withdrawal of the disciplinary process. I never withdrew it as the person that had the delegated authority to establish the process. Now, and it actually, in the entire report, the fact that the charges were never served, or rather there was an instruction not to serve the charges, is not dealt with in this report, which is a critical element of how the process collapsed, so to speak. Instead, the emphasis that is put is on the withdrawal that purportedly happened on the 22nd of June 2023. I maintain that if indeed there was no stoppage of my manager from serving Mkhwanazi, there would have been a dismissal inquiry and would not even be sitting discussing this report, because then the inquiry would have proceeded properly. I believe that the attorneys that were appointed would have succeeded in making a point that we indeed, must be legally represented based on the seniority of the employee and the complexity of the issues, as well as the seriousness of the allegations. So, yeah, unfortunately, again, we've got a report that is crafted. The key person who appointed and dealt with the issues is not consulted. There is no engagement. There is no request even for a submission, and adverse findings are effectively made about me without even the courtesy, the courtesy. As much as they say that I was no longer in the employ of the municipality, I can tell you, commissioners, I've had a number of instances where we have investigations, we've got processes that must be dealt with, and we have to go to a person who's no longer part of the institution and request, a submission, a statement, or whatever that will assist us to make informed decisions and to take the processes forward. we even, if indeed the person is no longer part of the institution and it's a legal process, we subpoena the person to come and provide critical information or evidence pertaining to the matter. But this report gets produced and there is no engagement at all.
Isn't the simple point, this, Mr. Ngciza, on this, that if there was a fruitless and wasteful expenditure within the meaning of Section 78, you couldn't have been the cause of it because you didn't make the decision not to continue with the disciplinary hearing. Yet, whatever happened to it, you didn't make that decision. You didn't prevent it proceeding. It's that simple, really.
You are correct, Madam Commissioner. Actually, I think your outlook on it is spot on.
Yes.
Because indeed, if there is a fruitless and wasteful expenditure, then the persons that stopped the serving of the charges, which effectively stopped the disciplinary hearing,
Yes.
caused the fruitless and wasteful expenditure.
Yes. Thank you.
Thank you. Mr. Ngciza, before we turn to the next theme, I would ask you to have a look at paragraph 110.4 on page 34, 110.4, and please make some concluding remarks to the Commission on what you believe was the true aim or the real purpose that motivated the commissioning of the report.
Thank you, Commissioners. I advance a view here that indeed, in my view, this report was procured with the main purpose of further suppressing the scandal involving Brigadier Mkhwanazi. Because we read this report nowhere, and I think at some point, Madam Commissioner, there is an interaction that we had about whether indeed there is a report that actually speaks to the merits post the Erasmus report. And I indicated that there is a report, but it doesn't speak to the merits. This report doesn't talk to the merits at all. Instead,
I thought such a report would be the 13 December 2023 report authored by the two advocates.
the one advocate.
Yeah, this one seems to be a witch hunt to look for people who leaked information
Yes.
to Jeff Wicks, and
That's-
also to investigate whether there was wasteful expenditure. So it doesn't deal with the merits of the allegations against Mkhwanazi. It's really a witch hunt to go after people who exposed that wrongdoing.
Exactly, commissioners. And to further illustrate that, commissioners, I'm not sure, but I know that that article is not in this bundle. In the News City Press newspaper on the 28th of September 2025, an article was published in City Press Online, where indeed this issue of the blue lights is articulated, and the response of both Mashazi and Behari in that article quotes this report to say that Mkhwanazi was vindicated by this report. They say that. I think I even saw another article where, I think on Saturday or so, where indeed Dr. Mashazi says she had commissioned an external investigation, and that external investigation proved that Mkhwanazi did nothing wrong. I have still not seen any investigation that actually says Mkhwanazi did nothing wrong. Mkhwanazi himself, in an interview on the 25th of September 2025 with ENCA, says to the journalist there are 3 investigations that have cleared him. I liked how the journalist responds and says, no, you have not been cleared. And he effectively makes reference to this report as one of those investigations. He is making reference to the letter of the 22nd of June 2023, the so-called withdrawal letter, as well as the legal department letter to IPID, that those have cleared him of wrongdoing. But in my professional expertise and experience, I have not come across any investigation that has cleared Brigadier DM Kwanas of the actual misconduct that was alleged. None whatsoever. So indeed, I agree with you, Commissioner, that this was intended, firstly, to sanitize the blue light scandal and therefore go after, because it doesn't only go after me, it also goes after the senior management of EMPD and says they must be dealt with as well. You know, and what have they done? All they did is to investigate allegations of misconduct as what is expected of any manager. Thank you, Counsel.
Thank you, Mr. Ngciza. That then brings us to our last major theme on page 34. It's titled Weaponization of the Metro Police and Labor Practices. Do you see that?
Yes, ma'am.
Thank you. Before you address the Commission on that, please have regard to the table you've prepared at paragraph 119.
Yes, ma'am.
Thank you. And that, please then use that table to assist you as you address the Commission from paragraph 111.
So I can just go through it all once.
You can summarize it with reference to the table, because the table condenses and reflects your experiences to the Commission. Thank you.
Commissioners, this theme effectively talks to the harassment that I have endured from the 7th of September until I think the 8th of March. On the 7th of September, when I was served with the pre-suspension letter that we've looked at earlier on, I was approached by 3 Metro Police officers. You recall, Commissioners, that I described how the offices are situated. I was in the building where Mr. Sheka sits, and then I was approached by 3 Metro Police officers at the parking lot. It's an open public area where I was served with a letter saying I must go home. I come from my boss's offices instead of in the privacy of an office. I was given a letter in public with Brigadier Mkwanazi observing and monitoring the situation when I was served with that letter. On the 11th of September, in the early evenings, it was already dark, something to 7, I received a call from my wife indicating that there were police at my house with sirens and blue lights. I stay, Commissioners, in a relatively quiet suburb, Faramia in Benoni. And the street that I stay in is next to my house is a estate. It has about only 4 houses. From in that block, from the stop sign up until the end of the street, my family is the only black family in that street. So you can imagine sirens and blue lights at night.
Then I spoke to the inspector who was there to say, why come to my house? You know, I mean, you guys have my contact details. I'm not even at the house at that particular point. When this happens, I just left Benoni town. I was driving to a church meeting because I'm also a leader in the church. I was driving to a church meeting. I'm on the N12 going to Benoni, to Davidton. And I speak to this inspector, and he says, no, but this is the instruction we got. Sorry, DH, you know, this is the instruction we got. Got from you. From who? From Klashega, that you must come to your house at this time. I'm like, but to come and serve a letter with 4 cars. You know, you will see on page 36, paragraph 119, that the people that were at my house were in 4 vehicles, 8 officers. All of them alighted the vehicles to serve a 2-page letter.
What are you alluding to when you mention that on your street you are the only black family?
Whether we like it or not, racial connotations exist. If indeed you are going to come to a person's house with sirens and blue lights, and you are going to see, Commissioner, as I go along, that indeed this, you know, it's a build-up. But if you're going to come to a person's house, you know, neighbors are bound to be interested in what's going on. You know, they are bound to be interested with what's happening. Oh, it's that dark, it's a haze. You know, but I'm gonna illustrate it even further with another incident, other incidents.
I get you. I did think that's what you were alluding to.
Yes. So I spoke to the inspector and suggested to him that I am on my way to Davidton. Why don't we do this? Why don't you leave my house? Because you have no business at my house. Your business is with me. Leave my house. Let us meet at Davidton Police Station, you know, which is not far from my church. So we can meet there, and then you can serve me. It's not a problem. He agreed. You know, because he was actually talking to me on my wife's phone, and it was on speaker. So my wife is standing inside the gate. They are outside. She hears the conversation. And then hardly 5 minutes, 2-3 minutes thereafter, my wife phones back. You know, no, these guys have left. What do you mean they've left? No, after he spoke to you, he called somebody, and then I could hear him saying, okay, HOD, no, it's fine, HOD. So they were then instructed that, no, we're not going to do that. Leave that letter with the wife. So the man insisted that my wife must sign for receipt. Now, my wife has got nothing to do with employment processes. In all the 25 years of our marriage, she has never had to deal with anything that has to do with employment processes until that day.
Mr. Ngciza, I mean, it may sound silly, but I imagine that this letter would have been carried by just one of the officers in the car, in one car, right?
Yes.
Physical possession of the letter.
Yes.
So you would have had 4 vehicles with 8 officers.
Yes.
There's a cost involved
in
having 4 vehicles and 8 officers coming to deliver one letter that is in one car.
In the hands of one person.
Yes. Am I correct?
Yes.
Do you think that whether the HOD or whoever might have had concerns that they may not be safe when they come to deliver the letter, and so they need to come in numbers because this might have been a risky operation. Do you think there might have been a basis for that? If we try to make sense of this, which on the face of it appears like a fruitless and wasteful expenditure, actually. But if we try and make sense of it, do you think that it may have been informed by an anticipation that there might be some risk involved in delivering this to you?
If, Madam Commissioner, Kashega didn't know my house, he had never been to my house, didn't know the area that I stayed in, I might even venture such a thought. But this is a person that had been to my house. She knew exactly where I stay, the environment in which I stay. She knew me. At no point would there be a basis to believe that indeed I would pose a risk to a police officer. Police officers that I've worked with for all these years.
Thank you.
So it was not about risk. It was about humiliation.
At that stage, you were still an employee of the municipality. So if they wanted to serve a letter on you, they could have summoned you to the office to come and sign the letter. You were still an employee on suspension.
Not even on suspension.
Was
Remember,
this before?
Commissioner, I have not yet actually been suspended.
Oh, that was before, yes.
Because this now is to serve me with a
The
suspension.
suspension letter, yeah.
Exactly. Besides me going to their offices, and commissioners, I've dealt with service of documents. Myself, in my office, we've utilized the EMPD to go and serve documents on especially senior employees. Firstly, we'd have a person or two people in one car. There's never been a point wherein you send a squadron to an official, But secondly, we would give those people that person's cell number so that they phone the person to say that, hey, we need to come and serve you this particular document that comes from HR or comes from the city manager's office. Make arrangements. Can we meet somewhere? That has always been the arrangement. You meet somewhere, you serve, they signing, and that's it. But even after I'd spoken to the inspector and there's an arrangement, there is this HOD, and the only people that I can think of would have been Kashega and or Behari. But those people had said that it was Kashega that had instructed them to come to my house. I then sent, because now when my wife told me that this is what had happened, I then sent Kashega WhatsApps.
Page 396, Mr. Ngciza, 396.
Commissioners, I sent 4 messages. The first message I sent was at 18:43, in which I asked the question, why send police to my house at night? And then I continue in Xhosa, utheni uhlukumeza usapho lwami? Bakwenze ntoni? Why are you harassing my family? What have they done to you? And then I sent another WhatsApp at 18:46. Sirens and blue lights at my house, Linda, causing a scene at my house, scaring my children and my wife. Then I sent another WhatsApp turning the Metro Police into a security branch of old, where people would be raided at night by police. Then the last one I sent was at 7 o'clock. Kulungile, makuqhutywe. It's okay, let's proceed. Now, as you can see, commissioners, all of them are one ticks. You know, all of these messages that I sent to Ms. Dlasheka were one ticks.
Please forgive me for a bit of levity on something so serious. I see that 2 of the messages are deleted. Those were probably expletives.
Yeah, they were. Honestly, no, they were correct. I had written them in some rather crude Xhosa, with then I was like, no, but this is my boss, so I deleted them. Quite honestly, I was really vexed by this, Then I reflect on paragraph 115 that I sent Ms. Dlasheka these messages questioning the conduct of sending police with blue lights and sirens to my house at night and thus harassing my family. Later, my wife advised me, honestly, commissioners, I was not aware. My wife advised me that if the message has one tick and you no longer can view the person's profile picture, it meant the person has blocked you on WhatsApp. I was not aware, because when I came back from church, well, I proceeded. I had a church engagement. I could not just leave it. When I came back from church, and now I'm sitting with my wife, and we're talking about this situation, and then I'm like, no, but in messages. She's like, I've sent her messages, but she's not responding, and she's like, okay, let me see. I show her the phone. She's like, did you have her profile picture before this? I'm like, yes, I did. She says, you are blocked. And since that day, I remain blocked. And again, this is a suspension process, Commissioner. It's not a termination, and nowhere near termination at that stage. For my superior then to block me in the midst of this conduct, and then I get blocked, I'm like, oh, okay. Also, to just link that, on the 7th, I received the pre-suspension letter. On the 8th, when I tried to send an email talking about irregularities in the pre-suspension letter that I picked up, I discovered that I was also blocked on the email system of the municipality. I could not access the system of the municipality. So in my view, it then meant that I was actually suspended from the 7th, because we ordinarily don't block people on the system.
Just remind us, the reasons for your suspension were 2, the qualifications and you approving invoices contrary to a memorandum.
Yes.
So because of that, 4 police cars in sirens and blue lights are sent to your house.
Yes.
This is something you could have received the next day when you go to work.
Yes. The next morning, on the 12th of September, we were awakened by a siren at the gate. And this is around 6 a.m. in the morning. My third-born son was already awake, preparing to go to school, and he comes to the room. Tata, kukhona abantu ke-18. About 18, and I think at that time he was doing grade 8. So he's like, but there are people at the gate, I wake up, I rush to the gate, I find 3 vehicles, branded vehicles of the Metropolis, at 6 a.m. in the morning. Again, I get into a discussion with them to say, but why? What's going on? Do you have to come at this time of the day and sound a siren? You're not only waking me up, you're waking my neighbors up. And this is a very quiet and serene street. Now, they indicated that they were instructed by Dlasheka to collect the laptop of the municipality at that time. I'm like, but this is not even working hours. Why specifically at this time? No, we're given instructions last night that we must come here and collect this laptop.
You
At
also,
this
you
time-
also mentioned that they had this time it was 3 vehicles.
3 vehicles with 6. Each vehicle has 2 people inside it. There were 3 vehicles that came to my house at that time of the day. That is reflected on my table on page 37. Then it
So
went
I'm
on.
suggesting, Mr. Ngciza, to the chairperson that maybe you're being unfair to these 3 vehicles. The one was going to carry the charger, the other one the bag, the other one the laptop. Be kind.
It's possible, huh? It's possible. It's possible, Madam Commissioner, that my laptop is heavy, and therefore they needed 6 people
See,
to come and collect
I
it.
know this is serious. I
Yeah.
don't mean to make light of it.
But again, these officers indicated, Madam Commissioner, that their actions are per the instructions to the letter of Xasheka. She told them that they must come at that time. They got the instructions the previous night to say that tomorrow morning, when you come on duty, start at Mr. Ngciza's house. So they clocked in at my house effectively. Then on the 10th of December, I received a call from an Inspector de Villiers who requested to meet me to serve me with an extension of my suspension. I requested that we meet at the Faramir Pick and Pay parking lot because I was at the Pick and Pay. I was busy with some groceries. And then he calls me to say, hey, Menir, I get a brief for you. I have a letter for you. Can we meet? And I know Inspector de Villiers. It's a person that I've worked with on a number of instances. And then we met. I said, you know what, it's fine. And fortunately for me, in this particular occasion, they were driving unmarked vehicles. They came, we met. Then they provided me with the letter. They were in an unmarked vehicle and they were wearing civilian clothes. But in this instance, there were 3 members. De Villiers was alone in his car, but then he was accompanied by a second car. Again, I signed for the thing, they left. The one that then became, or rather before they left, I asked the Villiers, why they need to use so many cars when they come to me. He indicated that he was instructed to use at least 2 cars with 4 members to come to me. Okay, it's an instruction. The one that commissioners, I think, was a bit, okay. Let me not characterize it. Let me just tell you what happened. On the 23rd of January 2024, there was no investigation, firstly, that was ever conducted regarding the allegations that I was suspended for. No investigation. I was then formally charged in the sense that a charge sheet was brought with 4 Drug Enforcement Unit branded vehicles in the middle of the day. It was around 2 p.m.
What exactly does the branding say? Does it make reference to drugs at all, or is it
It's
just
a drug enforcement
EMPD?
unit. It's EMPD, Drug Enforcement Unit, written in big blue letters. And I recall when they arrived, because they came and they did their siren thing, I came out, it was a siren thing again. It was right in the middle of the day, around 2. Came out, there were some neighbors of mine who were taking a walk. They stopped, of course, to see what's going on. And here comes this drug lord to come and receive a charge sheet from 4 drug enforcement unit vehicles.
But the charge sheet, even though it's a drug unit cars, the charge sheet still relates to the invoices and qualifications.
Exactly. But in this instance, Chair, one of my neighbors actually felt the need to come and talk to me. Came just to ask what's going on. I was like, no, man, it's work issues. It's work issues. He says, are you sure? I'm like, no, don't worry. Almost I work for the municipality, so no, these are my guys. And they're driven off that time. I'm like, no, these are my guys, don't worry, it's part of my work, Because, clearly, if you're going to be visited by a drug enforcement unit, it says perhaps you are part of a drug syndicate. I detail on paragraph 119 further instances in that table that on the 10th of February, again, I had people coming to my house to serve a further extension, an extension on top of the extension of suspension. And then on the 13th of February, the municipality in their charge sheet had invited me to a pre-trial hearing. I said that is not regulated by the prescripts of the DPCA, nor even the regulations on discipline, and therefore I don't see the need for us to have a pre-trial hearing. But then de Villiers, when I met with him on the very same 13th, because after I did not attend, they then sent de Villiers with a new letter where now they were changing the disciplinary procedure, because it was going to be a normal case. Then all of a sudden now they want to invoke what is in the DPCA in terms of clause 9, something called the summary procedure. Yeah, clause 9, an optional summary procedure. It's on page 12 of the DPCA. They wanted to do an optional summary procedure, which would have meant that instead of having a trial type of arrangement, a proper hearing, you just simply make submissions, and the chairperson takes a decision based on submissions, of which I in any event, objected thereto. But de Villiers indicated to me that your matter is hot, yo. We were stopped from going to other operations that were supposed to go to. We were stopped and instructed to go to the head office where the disciplinary hearing was going to be held. And 4 vehicles, their squad, was then told that they must not go to do law enforcement processes. They must come to the head office and guard the head office because my case is sitting.
Was this for the pre-trial? Pre-hearing?
Yeah, I was like, okay, fine. On the 1st of March, when they served me the letter contemplated termination of employment, again, 2 vehicles with 4 members. And then on the 8th of March, when they attempted to serve the unsigned letter of termination, they had 4 members and 2 vehicles. I record, Chairperson, that the total number of EMPD officials that were sent to me in the various occasions come to 48 people. And the number of vehicles that were used to serve me with single-page, 2-page letters comes to 23. And it must be noted, interestingly, that all these vehicles and members all of them fell under the command of Brigadier Mkhwanazi. It was not people from bylaw enforcement, it was not people from regional operations, it was specifically people from specialized services.
Did the drug enforcement unit also fall under
Yes.
specialized?
It also fell under Mkhwanazi. I must say that all of this was completely unnecessary and unpleasant, you would imagine. It was intended to humiliate me and my family and to cast aspersions on my person, my dignity and my character. Mr. Sheka was doing all of this knowing fully well where I stayed, my role in the community, and leadership in the church.
Mr. Ngciza, ordinarily, when assuming that the employee relations or in fact even HOD, Human Resources, Kasheka, is responsible for all these disciplinary processes in your absence, the serving of the suspension letter, pre-suspension, pre-termination. Ordinarily, how would you serve process on an employee who is on suspension? They are not in the office to receive the extension of a suspension because they're already at home, maybe even termination. Is there specified unit vehicles that you use? How does it work? And I ask the question to try and see if indeed anything is amiss in the fact that Mkhwanazi's section is the one that was delivering these documents to you.
Thank you, Madam Commissioner. And indeed, it's an important question that you're posing. The default position is that to arrange with the employee to come to their office, their place of work. Remember, when a person is on suspension, one of the suspension conditions is that you must avail yourself at any point the employer requires you during working hours. That's the default position. It's during working hours, and you must be available. If the employer gives you a call today and says tomorrow, and you are working at the Kempton Park Waste Depot, you are required at the office. So my team would then make that call to the employee. You are required at the office. One of my team members would then go to that depot and meet with that employee and effect service. Now, when do I use Metropolis? I use Metropolis, Madam Commissioner, when there is a senior person involved. And at Metropolis, it's unfortunate that our person that used to do this, one person, unfortunately, he had passed away, I think, early 2023. But in the course of time that I've been at DH Employee Relations, about, let's say, 6 years, there is a specific person that I had an arrangement with Metropolis that this, if I need to serve an HOD or a divisional head or somebody senior, I would not really call them into the office for service. I would not call an HOD, come to my office, I want to serve you something. I would request this gentleman who was a senior in the Metropolis Department, I think was a deputy director. I would talk to him that, hey man, can you assist us with servicing a particular letter at HOD so and so? Here is the address, here is the telephone number, can you make a call? So that he has a sense of where the person stays. Then make a call to make arrangements to meet with the person either at a restaurant or meet wherever, that the two of them would agree. That has been the norm. I would not use Metropolis officials or even this specific gentleman. And even when I use that gentleman, it's via the chief's office. If the chief Mapia is not there, I would talk to Chief Mzolo, Deputy Chief Mzolo, then we'd make those arrangements. Oh, no, and it's fine, I'll talk to him. I would not go directly to him. I'll talk to the chiefs. They are the ones that will then engage with him. He will call me, we'd meet. I'll give him the necessary documentation. contact details and everything. He makes that arrangement with the person. The service is done. He brings back proof of service. You know, in respect of officials lower down, no service via Metropolis, except for one. There is a gentleman who actually we had to dismiss because he was refusing. He carried a firearm to work, and he was very obstructive and very rude, insolent. We charged him, but eventually the municipality was like, this person has to go. You know, and everybody, the head of department, the supervisors, the city manager, the mayor, everybody was like, this person has to go. You know, and we took a decision that this is out, totally out. So the service to that person, because of the nature of the person, you know, and the inherent danger that he posed, we effected the service to that person via a Metropolis. I think it was one vehicle with 2 officers that had to go and serve him. And it only happened once. That service was to service the termination when we sent junior Metropolis officials to go and serve him.
Yep. Thank you, Commissioner. Mr. Ngciza?
Yes, ma'am.
My apologies. Could I ask you to turn to the next page, your final paragraph there, paragraph 122. I would invite you to read that into the record, please.
Commissioners, I have listened to the evidence of Chief Mapieye and Deputy Chief Spies before this commission. Viewed cumulatively, and in terms of my own experiences, the commission is able to see a pattern whereby Dr. Mashazi, Mr. Shega, and Advocate Behari used labor processes, suspensions, special leave, disciplinary proceedings, even terminations, to frustrate and get rid of employees who opposed their unlawful conduct that relates to Brigadier Mkhwanazi at the time, up to the point where he became even the Deputy Chief of Police. There is an aspect that I'm not even sure that Chief Mapieye knows that I know this, but there's an aspect that our commissioners just want to bring to our attention that was relayed to me by 2 heads of departments in the municipality, who are still in the municipality. And the person is like, no, man, we went into a senior management team meeting. Senior management team meeting, commissioners, is the city manager and all the HODs in the municipality. It's supposed to be a meeting that discusses strategic issues about service delivery, implementation of resolutions of council, mapping processes that must be implemented to ensure that the citizens of Ekurhuleni are better served. And this person says to me, you know, we went into a meeting where for about 45 minutes, the discussion was about my PA and Mkhwanazi. Like what? Yes. Where my PA was lambasted from start to finish on why is he not able to work with Mkhwanazi, and told that whether you like it or not, you will work with Mkhwanazi. If you don't want to work with Mkhwanazi, you better leave. So these HODs expressed the frustration to say, how can we go to an SMT meeting and we must sit there and listen to this type of engagement? And the poor chief was stunned. You know, both of them are like, he was like, no, ma'am, it's fine, we will work. No. I know that you hate Mkhwanazi. You know, I stopped you from doing this nonsense that you wanted to do against Mkhwanazi. You and your species were an alimaburu how. You and a white man. 2 senior people experienced that. And when we talk about this relationship,
And this is soon after Mkhwanazi was appointed as Deputy Chief of Police. You know, and this is at the point where indeed Mapie, as he had testified, was still having problems about how that appointment had been effected. And then he gets lambasted in a senior management team meeting that is supposed to discuss how we must deliver services. That meeting became about Mkhwanazi and why Mkhwanazi must be treated as the Prince of Ekurhuleni.
Thank you, Mr. Ngciza. We have then reached the final topic in your witness statement, paragraph 123. It's titled Impact on My Life. I'd invite you to make some remarks to the Commission on this aspect.
Commissioners, the impact on my life that this whole ordeal has had has been rather devastating. Professionally, my standing in the local government sector has been severely dented by this experience. As much as I was the divisional head employee relations in Ekurhuleni, but I was also the provincial chairperson of the Salga Human Resource Practitioners Forum, which also made me the lead or chief negotiator of the employers in local government in Gauteng, you know, which is a role that I had held in the sector for more than 10 years as the chairperson of that forum and leading negotiations on behalf of all the municipalities with the trade unions in the bargaining council Gauteng division, Central Gauteng division. Of course, except for Tshwane and Johannesburg. I don't want those colleagues to say that I represented them. I represented all the other municipalities. These two municipalities had their own divisions where they negotiated. But I was also the leader of the employer in Ekurhuleni on negotiations with organized labor since 2003. In December 2022, I had received a 20-year recognition award for my contribution to the bargaining council in terms of its establishment, its progression into a fully fledged bargaining council, its engagements in terms of stabilizing the local government sector. You know, I was one of the people that was actually awarded for my 20 years service in the bargaining council because I served in the executive committee of the bargaining council at the national level. I've served, and at the time of my dismissal, I was still a member of the employer party in terms of the bargaining committee at the national level. I was also the chairperson of the technical advisory committee of the bargaining council, a committee that dealt with processes of how the rules in the bargaining council are to be implemented, the appointment of commissioners. You know, I was the chairperson of such a committee. But the treatment that I received sought to annihilate my career just because people had to protect a criminal enterprise. Personally, the impact on my wife, my mother and my children, as well as my broader family, has been immense. Because, I mean, when this whole thing erupted in 2023, my name was brandished all over the place. I was in newspapers, I was on TV, you know, people had issued statements about my suspension and all sorts of things. So my family then had to now respond to a situation that was created to place me as a person of questionable integrity. And indeed, my family has been stigmatized by the flagrant lies
that have been spewed, impugning my image and standing in society. Communally, this ordeal had resulted in an attempt to remove me from ministry in the Anglican Church, whereat some congregants had invoked a process of a petition due to the lies that have been spread and the falsehoods that have been spread regarding my name. A petition was then lodged with the office of the Bishop of the Anglican Church in the Highveld Diocese, seeking to remove me from all ministerial positions in the church. At the time, I was a church warden in a parish, and I'm also a lay canon, which is an advisor to the bishop in the Anglican Church. So a petition premised on a notion that I had been dismissed for fraud and dishonesty, was then submitted in an attempt to indeed make me sever my ties with the church. And this was all because of the shenanigans that are happening in the city of Ekurhuleni.
What came of that attempt, if you don't mind saying?
Cool heads prevailed. Cool heads prevailed. As much as there was that petition, I was summoned to the bishop's office. I sat with the dean of the cathedral, and we had I think 2.5-hour conversation where I was able to also, without getting into the type of detail that I've gone into in these proceedings, but just to alert and highlight to him the intricacies that are involved, and the fact that what is in the newspapers is not always what is actually prevailing, unfortunately. And quite honestly, commissioners, everything that had happened to me, I don't believe that if I was not in the church, I would have been able to survive it. The fact that I was suspended, fortunately, the rector of my parish at the time held a meeting with me because my name was all over the place, called me into a meeting. We had a 3-hour session, one-on-one, and that then provided me with a pillar, and I poured my life, my time, my resources into devoting myself to the service of ministry in the church. And that soothed my spirit.
Ms. Ngciza, when you address 128, I'd like you to address the reasons given for your dismissal. You will recall that one of them was you did not provide the advanced diploma in labor law, but the second one was that you did not sign your contract of employment. So when you deal with that, can you just address those reasons and whether or not they were valid, or if they were used as a smoke screen, whatever your view is, can you just address the reasons for your dismissal as set out in the dismissal letter?
Thank you, Commissioner. Commissioners, first let me start with the issue of the contract, non-signing of the contract. Fortunately, in the course of the arbitration proceedings, I submitted an unfair dismissal dispute. The employer then said, no, there was no dismissal. And they alleged, these are the funny things that Advocate Behari does, there was an allegation that there was no employment because I did not sign the contract. The commissioner in the proceedings said, but signing of a contract is not a requirement for the existence of an employment relationship. And the reasons why I did not sign the contract are well known to the employer. My second contract, my first contract I had signed, it was perfect. My second contract had issues. And I said, no, but I can't sign, correct these issues. You know, and I submitted to Xolani's office. You know, for some reason they were not corrected. But this was usual in the municipality. There's quite a number of even HODs. There's an HOD or 3 HODs that I know of that had not even signed their contracts, even though Section 57, especially for HODs, is very clear that if there is no signed contract within 60 days, then the offer of employment is withdrawn and therefore the relationship is terminated. But this is now, in respect of myself, 20 months down the line, you know, the issue that there is no signed contract was raised as a basis upon which I'm terminated. But if you look at the letter that we have requested, Commissioner, where there is the call for representations, the issue of the unsigned contract is not raised to say that make a representation on this. See, so make a representation why the contract is not signed. And then on the issue of the so-called non-submission of the advanced labor law, there was a submission of the advanced labor law, commissioners. Firstly, UNISA had provided, because I had lost the certificate around about 2009, we had applied and then they provided a record, a transcript to say that this gentleman, Xolani, Mr. Ngciza, you have done this course, you have passed the exams, indeed, you have the course. And they even indicate the mark I had gotten in the exam. And then in 2022, again, UNISA issued a similar letter to say that, no, you've got this. Now, the argument that effectively gets raised is to say, but this communication from UNISA, as much as they are from UNISA, the academic institution that you went and did the course at, and surprisingly, I was part of a cohort of employees, 20 employees of the municipality, that went to do the advanced labor law program at UNISA. We didn't even register ourselves. We don't even have student numbers. It was a workplace skills program in partnership with UNISA to do the course, paid for by the city of Ekurhuleni, administered on our behalf by the city. We did not even go to campus. The lecturer went to the municipality and lectured us in a lecture room of the municipality. Beautiful arrangement. I then get dismissed that I don't have that course, even though everything was submitted to the municipality and all the records. So indeed, when this thing was becoming hot as it was, I communicated again with UNISA. And I copied Xolani in all my communication to say, UNISA, you know what? As much as you've given me these documents and you've given the municipality these documents, the municipality still insists on a certificate. And the people at UNISA then said, okay, fine, do these processes. We are going to issue with the replacement certificate. And Xolani is copied. And the person who signed the termination letter, Maseko, is also copied. On the 20th of March, UNISA then submitted a replacement certificate. That replacement certificate was then also sent. What they did, they emailed and then indicated in the email that they're also sending a courier to my house with the replacement certificate. So I took that email and I sent it to Xolani and Maseko to say that this thing that you're complaining about, here it is. 2 days later, I got dismissed.
That certificate exists?
Exists.
So can you share it along with that letter that you referred to of 1 March?
Exactly.
Thank you.
Yes, we'll attend to that. Thank you, Commissioner.
Okay. So, paragraph 128, with all my dedicated service and accomplishments in the municipality, and I can assure you, commissioners, I have a lot of things that I've done for the municipality. I don't even think that I actually took you through my experiences where at some point I was held hostage. There is a point where there was a red tax fund that was established in an attempt to assassinate me in 2011, and all sorts of other things where indeed I have experienced a lot of attempts even on my life and my person as a result of me defending the municipality. I was suspended surreptitiously without even being afforded a contractual opportunity to advance representations to be heard. This matter is still to be finalized in arbitration proceedings. I referred a dispute in September 2023. Some 26 months down the line, I still have not been accorded justice. And primarily because the municipality has done everything to delay the matter. The initial team that was dealing with the matter, commissioners, to give you a picture of what has been happening, they had an advocate who had a pupil in the matter. Then they had an attorney who had a candidate in the matter. So he had 4 lawyers, effectively. And then that entire team is no longer involved. They started off, removed the attorney, and then the advocate. Now they have an attorney and an advocate, so 6. And then I was summarily dismissed without a disciplinary hearing for a qualification that the municipality took me to. The academic institution provided evidence of the qualification, but nonetheless, I was terminated. In this particular matter, they had an advocate and 2 attorneys in the dismissal matter. That advocate also dropped the matter. At some point, this matter commenced in March 2024. It is still ongoing as we speak as well. And again, all sorts of things have happened to make sure that the matter doesn't finish.
Is it before the bargaining council?
Yes, both of them are before the bargaining council. So you had 3 legal practitioners in the dismissal matter. In the disciplinary matter, you had 3. You had the attorney was presiding, an attorney and an advocate. So all in all, the number of lawyers that have been used by the municipality in my matters are 12 attorneys. On top of the resources that were used to harass me, 12 attorneys. And I've only used a shop steward in all of them. My suffering was for one thing and one thing only. On numerous occasions, commissioners, Dr. Mashazi would accuse me of not being loyal to her. She has done this in front of the chief of police, the CFO, the CIO. She has indicated, when you are not loyal to me, I appointed you, but you are not loyal to me. And that is exactly why I find myself in the predicament that I'm in. I was not loyal to Dr. Imogen Mashazi. Thank you.
Thank you, Chairperson. That's the conclusion of Mr. Ngciza's. My apologies.
Mr. Ngciza, it's unrelated to this last part of your evidence, but it is touched.
Mr. Ngciza, I'll quote to you something that was said by Commissioner Spies, and then I'll put a question to you. On the 10th of November 2025, Commissioner Spies said the following: our disciplinary agreement has already been touched on. It deals with all municipal employees in exactly the same manner, irrespective if you are a plumber or an admin clerk or a police officer. We are dealt with in terms of that disciplinary agreement in that manner. I skip some parts of this evidence, and he continues. A municipal police officer is treated, does not matter what crimes they committed, they are treated as if they are a normal council employee, and they are not treated as if they are police officers, which can intimidate witnesses, and therefore the public does not want to come and testify in our disciplinary cases. I skip again. That is one of the problems that we have in this environment where we are dealing with officers. I end the quote there. As an expert in HR management issues, do you share Commissioner Spice's concerns about disciplining Ekurhuleni police in exactly the same way civilian employees are disciplined? If you do, why is that so?
I will deposit a response, Chair, by referencing something that the second Chief of Police of the city of Ekurhuleni once said. We were at a budget steercom meeting. Unfortunately, I'm an institutional memory person. This is around 2007 or so. And that Chief of Police was one Robert McBride. We're sitting in a meeting, we're dealing with the budget issues, trying to make a determination of how to adjust the budget of the municipality. And the then city manager had problems with the submissions that were made by EMPD. And Chief McBride, as he was then, commented to the executive mayor, the late Dumangos. He says, Comrade Duma, this is not correct. I'm a policeman. I'm not going to be dictated upon by a civilian. This notion that police will be treated like any other department or like any other employees is nonsense. It must stop. We laughed.
And perhaps for context, parts of what I skipped say, this being said by Commissioner Spice, that with SAPS, the process is different.
It's different.
Please continue.
Yes. We laughed. I mean, it was Robert, but there is truth to what he was saying. And one agrees, and indeed, I know that the Chiefs Forum has raised this issue, and it is something that SALGA, as the employer organization, needs to zoom into. You can't have a one-size-fits-all arrangement. The police are in a command structure. They are uniformed service, the Metro Police. There is, for instance, a notion of you obey and complain later, whereas in the civilian structure, you seek consent. Employees will tell you that, no, I'm not going to agree to this transfer, I'm not going to agree to that. There must be some consent, there must be some agreement, there must be some procedure. And sometimes police require a different approach. I agree fully that indeed it's an issue that the sector must look into. This collective agreement that we are talking about has been extended to 2028. It expired in 2023, parties extended it, and then now they've extended it to 2028. I think this is an opportunity, such things that are actually going to be coming out of this commission. It's an opportunity that the parties in the bargaining council
revisit the approach to collective bargaining in the sector. You know, I once made a presentation, Chair, to the effect that local government is a multilateral sector. We are not like your engineering services sector, because we have engineering services within local government. We've got health within, we've got police within. So there's a multiplicity of sectors in local government. You don't have it as a singular sector because we've got various occupations in the sector. So indeed, perhaps when we look at our processes, there is a need for us to identify that, recognize that, appreciate it, so that our collective bargaining approach is able to cater for the different functional dispensations that will then pertain to specific functions. You can't treat a Metro Police officer like a water services, like a plumber. A Metro Police officer and a plumber are totally different. You know, they're totally different. The environments in which they work is totally different. I totally agree that indeed the issue is in the approach that the employer must adopt in the negotiations. I know organized labor would prefer a situation when there is a singularity of processes, because it's their members that they seek to protect, but it's not protecting the citizenry and it's not protecting the sector itself. So I want to agree with it.
What exactly within a command structure, as I think you referred to it, dictates that the processes must be different? Right at the beginning, you referred to the fact that the nature of the environment within the police is one of a command structure. And what you said then seemed to flow from that structure. So what I want to understand is what exactly within the command structure dictates that the process should be different, as you suggest, as you and Commissioner Spies suggest.
The police structure, Chair, you can't you can't have room for insubordination, for insolence. You can't have room for situations wherein a commander's command can be subjected to question. Because the problem that you're faced with is these people deal with serious issues where indeed lives can be at risk, lives can be at stake. You know, so if indeed in a command structure, the commander would not have the authority because he must be subjected to certain processes, you know, because now those that is commanding cannot actually have got leeway or have got room to challenge the command. And they've got room to challenge the command because, hey, I'm going to submit a grievance. If you do this, if you instruct me like this, if you're commanding me to move from this deployment to that area, because sometimes you find that the levels of crime and the levels of what you call of risk to the community differ, and therefore you need to move resources and move them with immediate effect. And people tell you, but you are transferring me, you are doing this to me, you know, and my terms and conditions of employment require that you must consult me before you can transfer me. And if you're going to transfer me, you know, this. That is what a normal employee raises, and that is what we are faced with, even in Metro Police, where indeed, because as much as they're in a command environment, but they've got the rights and everything that accrues to a normal civilian worker. Now, then your command structure is compromised. You know, it's a command structure. There are instances wherein indeed decisions that are taken by the commander must be implemented with immediate effect. Otherwise, we are not able to respond to life-threatening, to risky situations with immediacy. That's where I find the challenge.
And lastly, again, right at the beginning of your response, you said within this command structure, it's a case of obey and complain or challenge later.
Yes.
Why do I seem to think or recall that there's something that police are entitled not to obey an unlawful order? I may be wrong, but it's something we can check because it's a question of law. It doesn't really require evidence. But I'm asking you, or I'm engaging you on it because you mention it in the context of saying it is justified to have a different process for police. So why do I seem to recall that there's something that says exactly what I've said?
You are correct, Chair, that indeed where the instruction or the command is patently unlawful, an officer would have the right to disobey it at the instance of the instruction being issued, as opposed to follow it and then, because if indeed the command is that shoot this person and the person is unarmed, the person has not done anything, and the instruction is that commit murder effectively, then we not excuse an officer because it was an instruction from a superior, because that is patently unlawful, but I'm transferring you. There is nothing unlawful about transfer. It might not be procedural, and therefore you would want to lay a grievance or do whatever, but if indeed there is a basis upon which I'm saying as a commander that you need to move, as much as you are deployed or are located in precinct A, but the situation requires that we need you at precinct B. As much as you might not agree with it, but we need you because the situation calls for it now. You can go to precinct B. That is what is obey and complain later. You go to precinct B, and then you submit your processes. But you go to precinct B and you perform as instructed at precinct B. Otherwise, if indeed you allow that a policeman would say no, because he's citing that there is a labor process that must be followed before I say yes. I need to consult with my union, which will be available next week. And then the union, when it comes to the meeting, and then they're going to require that you give them these further particulars about the risk assessment that you've conducted, why you need more police officers. And that time, the people at precinct B, the residents that must be serviced by precinct B are suffering.
Thank you, Mr. Ngciza.
Thank you, sir.
Maybe firstly, just as a follow-up to this discussion, Commissioner Spies said, and his words was, it has been presented, this issue has been raised at the highest level in Salga. And then he used the words, and I want you to maybe explain if you know anything about it. And then he says, but to date, we have been denied that. Now, the question is, has this been debated and rejected at Salga, or it's simply a matter of it has been shelved and all he was conveying was it hasn't yet been legislated?
Madam Commissioner, I remember Salga is an institution of organized local government, and it deals with the many facets that inform local government. Indeed, Commissioner Spies might have had that discussion in one area that deals with community safety processes in local government. From an HR working group perspective, like I indicated that one even made a presentation in Gauteng, where indeed we're talking about the multilateralism of the sector and the need to differentiate in terms of our terms and conditions, in terms of our processes, in terms of our discipline management processes and all sorts of things, to differentiate amongst the various categories and occupational arrangements. So their process as the cluster of community safety and the likes might have raised the issue, but at a national collective bargaining level, the issue has not actually taken root yet. And before you can even get to that point of the collective bargaining regime, the employer body as SALGA, inclusive of the HR components of SALGA, must first come to a determination that as the employer, we want therefore to advance this multilateralism of the conditions of service, inclusive of discipline management, as informed by the various occupational categories.
Thank
At
you.
this point, we have not gotten there.
It hasn't come up yet. Lastly, Commissioner Spies also testified to 3 police officers who are in Brigadier Mkhwana's section who have appeared in court, and he did name them. This is Stolz and
Mackenzie and Twala.
yes, and this relates to the matter of Smokes and King's supermarket where cigarettes and someone was kidnapped. Now, his testimony was that did get to a disciplinary process being instituted, but then the matter was taken away. I think there was an appeal supposed to start on day 1, and he attended to testify. And then he says that when he got there, he was told it had been taken away, and nothing's ever happened about it. Do you know the circumstances in which this would have happened?
I did testify on this, Madam Commissioner, I think sometime early yesterday. We had appointed effectively the same disciplinary committee that we had appointed for Brigadier Mkhwana as well, Now, I testified earlier on that the presiding officer, withdrew from the matter, citing non-payment of his invoices by the municipality on other matters, and unfortunately, this happens in August, and I get shipped out. I got shipped out, so as I understand it, no other presiding officer was then appointed,
Thank you. Thank you, Mr. Ngciza. Thank you, Ms. Mthaseti.
Thank you, Chairperson. That's the conclusion of Mr. Ngciza's evidence this afternoon.
Thank you very much, Mr. Ngciza.
Thank you, sir.
Thank you. Who do I look to?
Chair, we proceed normally at 9:30 tomorrow morning with the next witness.
Let's adjourn until 9:30 tomorrow.
Yeah.